keeping a tight rein on them.
Not really.
Sure, you're showing them much of much people.
It's gonna say, so there's gonna be no all restricted on men,
You're only gonna have
one more.
4 or 5 here. One person, we expecting 4 stars, need a 4-person for. But with overshooting, they're gonna be tied up about 5 and 30.
So the only
That's a very
person,
precise time.
5:36. Mr. Rhodes was looking for, and Representative Miller.
oh, that's right, okay.
Get it over
Yeah.
Okay, I'm going to be quick over here.
Okay,
I don't want to roll around up here.
And do it really well.
it is just,
I did.
so red mic is.
Red light,
Got it.
red light, red light.
Okay. Yes. Of the same class.
Now, Chair, you now have a quorum.
Okay, thank you very much. No, please. All right. Since it appears we have a quorum, I hereby call to order the second meeting of the task force for the review of the process and procedures of the Office of the Inspector General the ethics officer, and the governing board of the office of the inspector general and the ethics office. Mr. Pascal, please call the roll to document which task force members were able to join us here today. Okay, that's fine.
The Honorable Leo Ward Sears, Mr. David Dove,
Present.
Representative Tanya Miller, Mr. Norman Brothers,
Present.
Honorable Marcy Carrier Overshoot, Honorable Howard Shook, City Attorney Patrice Perkins Hooker,
I'm present, but I'm just present for the purposes of being an aide to the task force. I'm not a member to the quorums set by those other folks.
got it. Madam Chair, you have appointed.
Okay. Judge Dean.
Well, maybe at the next.
No,
My
no,
apologies.
Judge Rick Dean.
Rick Dean.
Richard Dean. Yeah.
Richard Dean,
Okay. So,
Present.
you have a quorum.
all right, so we got it. Please do not excuse. So, thank you. All right, the meeting agenda was distributed to everyone late last week and published to the public. Does anyone have any additions or modifications to make to the same? All right, seeing none, I will entertain a motion to approve the agenda as published.
So moved.
So all in favor say aye.
Aye.
All right, the motion has passed. The minutes of the first meeting of the task force were also distributed to the task force members last week for your review and consideration. Does anyone have any corrections or additions to these minutes? All right, hearing none, I will entertain a motion to approve the minutes as presented.
So moved. Second.
All in favor say aye.
Aye.
Any opposed? Okay, the motion has passed. Now that the minutes are official, these will be added to the website, listing the activities and materials received by the task force after today's meeting. Mr. Pascal, can you please provide the website address for the public watching? Oh, okay. Can you hear me now? Is it better? Okay. Is there anything I need to repeat? I'll just repeat the last one. Okay. The minutes, now that the minutes are official, these will be added to the website listing the activities and materials received by the task force after today's meeting. Mr. Pascal, can you please provide the website address for the public watching?
So yes, public watching can view at www.atlantanga.gov, or you can go to www.citycouncil.atlanta.gov, select council division, council communications, and you will see meeting videos and look for the special meeting section to find this broadcast.
All right, thank you very much. All right, during our last meeting, Council Member Shook indicated that we should hear from stakeholders and parties who have had experiences with the concerns raised about the subjects of our task force's purpose, and from those who run an OIG or an ethics office. The members of the task force have received additional information from various entities and persons since our last meeting. These written documents have been useful to providing additional input into the task force's work. Also, during our last meeting, 2 to 3 members of the task force agreed voluntarily to discuss the information that they needed to accomplish their purpose and make recommendations to the city council. Representative Miller, now that you are here, and if you'll note that she is here, I think that you and Councilman Overstreet agreed to work with Judge Dean to put together something on this. Is that correct?
That is correct.
All right, do you have any recommendations for a group to consider for the next meeting?
I do.
Okay.
First of all, good afternoon, everybody. Good afternoon, Madam Chair.
Okay,
Representative Miller,
Am I not on?
red is hot, green is not.
Thank you.
okay, good.
It was just, it's on, thank you. Okay, I'll start over. Good afternoon, everybody. Good afternoon, Madam Chair. Thank you for the opening remarks. You were correct. We did, at the beginning, I guess, or perhaps the close of our last meeting, discuss perhaps coming up with a process that might help the task force work through the mandate. I think it is first important to frame the mandate so that it becomes clearer what our process is and what we are trying to accomplish. The purpose of the task force is to review the processes and procedures of the Office of the Inspector General, the Ethics Office, and the Governing Board of the Office of the Inspector General and Ethics Office. Specifically, we are tasked with examining these processes and procedures and making any recommendations upon completion of that examination. Our mandate is not to pass on merits of any investigation, but rather to look strictly at processes and procedure. So as we move forward, Madam Chair, you summarized, I think, pretty well the materials that we have been provided. We have reviewed substantial submissions, as you stated. This list is a summary and it is not necessarily exhaustive. We've received materials from the Inspector General. This includes nearly 250 pages of documentation to include materials from the Baltimore City Office of the Inspector General, the Baltimore Blue Ribbon Panels report, and in addition, we have reviewed, or at least I have reviewed, the Baltimore OIG policy manual as it related to that work. We've received information from the mayor's office. We've received submissions from outside organizations. We've reviewed relevant legislation, and we have reviewed submissions from citizens who wish to provide this task force with input. Now, I've personally looked at all of these submissions, Madam Chair, and more, including publicly available information regarding the United States Inspector General's processes and procedures, the New York Department of Investigation, which supervises that city's IG office. We've looked at the reporting structure within the Department of Investigation in New York and its relationship to the city's overall governing structure. I've examined materials from the Association of Inspectors General and the Council of Inspectors General, as well as materials from the American Federation of Government Employees on worker protections as it relates to IG investigations. Our focus again has been on policies, procedures, and best practices and how those are generated. We've reviewed documents related to our own governing board, including their bylaws and their code of conduct. Today, Madam Chair, we will hear from a wide range of stakeholders as indicated in our last meeting. I have prepared questions for the presenters, as I'm sure my colleagues may or may not have. If time does not allow, I will ask for leave to submit these questions in writing and receive written responses so that we can enter those responses into the record. I also do expect that we will ask that additional documentation be provided to the task force as needed and upon conclusion of this hearing. So the process will be, we will listen to stakeholders today. We will do some fact finding in terms of asking questions to better understand the processes and procedures that are in place. We will request additional, likely substantial, additional materials, data, and information from various stakeholders to assist in our review and formulation of our recommendations. I have consulted, as Madam Chair stated correctly, with my colleague Rick Dean, who's seated to my left. I have also had an opportunity to discuss this process with Councilwoman Overstreet. After we have the hearings today, we hear from the stakeholders, we request additional documentary evidence. It's my hope that we will be prepared to evaluate our mandate and begin the process of recommendations, and we will have to see where, of course, that evidence leads us. Our goal is to have every relevant document and every stakeholder heard, every relevant document reviewed and considered, and every stakeholder heard. We will utilize small group calls as necessary to complete our mandate. Our hope is that we will comply with the legislation that gives us the authority to be here today and considering those things. And it is our hope that this framework of listening to the stakeholders, receiving information by written submission, requesting additional documentary evidence that is relevant, requesting additional documentary evidence as necessary and relevant will help us be thorough, transparent, and inclusive in our approach. So,
Thank you very much. Anyone else wants to add to that? All right, thank you very much, I appreciate it. All right. Thank you. After our last meeting, I assembled a list of 18 potential presenters from the types of groups that were suggested by the members of the task force. They were invited to come here today and make presentations on information that they want the task force to consider as we develop recommendations to submit to the city council on ways to address their stated concerns. This list included subject matter experts from the Association of the Office of Inspector Generals, the State Inspector General, the City of Atlanta Inspector General personally, all members of the governing board for the Office of Inspector General and the Ethics Office and the Ethics Officer, representatives from employees and union associations, and the Chief Operating Officer. As we have stated publicly before, this task force was not assembled to remove the office of the Inspector General or the Ethics Officer. We are here rather to provide any assistance that we can to resolve problems and concerns that have arisen in the operations of these offices and the actions of the governance board. Mr. Pascal, as clerk for the task force, you have received responses and presentations from several of these invitees, is that correct, sir?
that is correct.
How many invitees will be making presentations today?
So this afternoon, we have a list of 16 speakers and presenters that we've received information from. This includes written reports that should be in.
Okay, very good, thank you. All right, well, each of the presenters were informed that their presentations had to be submitted to Mr. Pascal by last Saturday, and that they were to be provided with 10 minutes apiece to present, and then the members of the task force would be given up to 5 minutes collectively to ask any questions of the presenter. As you can see, we will be here for quite a while today, but this step is extremely important to make sure that everybody's perspective has an opportunity to be heard. With that said, Mr. Pascal, would you please call the first presenter?
Madam Chair, before he begins that, I wanted to state for the record that we received presentations here that will be made, available also online at the task force site. One is an actual written response from Will Fletcher from the Association of Inspectors General, and then one from Nigel Lang at the office of the Georgia Inspector General has also provided comments to us.
Okay, thank you very much. Mr. Pascal.
All right, first up, we have City of Atlanta Ethics Office.
You were keeping time? Okay, thank you so much. Thank you. They tell me that red means
All right, thank you.
okay.
All right, good afternoon, Madam Chair and members of the task force. My name is Jabu Sengova, and I currently serve as the City of Atlanta Ethics Officer, and I've been in this role for 7 years and 15 years with the office. I will be presenting today within that time frame on behalf of the Ethics Office, and thank you for the opportunity to address the task force. And I also have my deputy here, Carlos Santiago, in the audience, as well as members of the staff. So very quickly, in terms of, sorry, the first slide. So I'm going to run through this slide because I do understand the time limitations. In terms of who we are, we were established in 2003. We just celebrated 20 years of the Ethics Office, and we currently have 13 full-time employees. Again, we do report to the 9-member board, and members of the board are here today, as well as in terms of what we do, briefly for the benefit of the public who may not know about us. We provide ethics training, we give advice on conflicts of interest, investigate ethics complaints, prosecute violations of the Code of Ethics. We manage a disclosure system and coordinate our integrity hotline. In terms of our jurisdiction, we are really just pretty much limited. We have a limited jurisdiction. Some of the main areas that we oversee are conflicts of interest, of course, misuse of city property, outside employment. So these are some of the subjects that we really cover in terms of our areas. All right, I'll just go ahead and get right into our investigative process because I know that's one of the things that the task force needs to hear about, and just again summarize within the time frame. We do receive complaints and tips from different sources to include referrals. So I knew that was one of the questions was asked, how do we receive complaints? And once we receive our complaints, through our initial review by the investigative team, we have an experienced investigative team that looks at to see if we have jurisdiction to even investigate the matter, and we develop plans. The standard review that we usually follow is called the reasonable articulable suspicion standard, and that's pursuant to city charter. And I'm just summarizing some of this stuff because, of course, the task force will have an opportunity to review that as a part of your review. Another part of our process is the request for city records. So we do need, of course, access to city records because that is a critical part of our investigations. However, our goal is to strive with city law and procedures. Access to city records, sensitive city records, is limited to only key personnel within our office. And of course, with proper oversight by attorneys. I'm an attorney and Carlos is an attorney as well. We have 2 others on staff. So we make sure that that is part of the oversight. Any access needed for city-issued devices, we usually coordinate with Atlanta Information and Management, which is our technology department, as well as the agency in question. So that is part of our process. Just continuing with our process, we try to maintain the integrity of our investigations, because that is paramount. In terms of our interviews, we utilize a separate interview request for subjects and witnesses, and generally include the general purpose of the interview. Employees are allowed representation of their choice because these are administrative proceedings for ethics matters. And we use an employee acknowledgement form which outlines the scope of our interview and employees' rights, and that's a part of every interview. So for example, if an employee shows up without a representative and changes their mind, we stop the interview. And interviews are only conducted in person at city facilities or via virtual platform. Conclusion of investigation. When our investigation is over, if there's no violation, we close that matter administratively. Of course, we do make sure we have a memo final report to that effect. If a violation is found, we issue a final decision with findings and any administrative sanctions that are may be issued. And the recipient, if there's a recipient who has an adverse decision, that respondent has a right to appeal that final decision from the ethics office to the governing board. Let's see. Yeah, so just wrapping up, our investigative process is something that's been in work in the years. Over the years, we've had to work through it and fine tune it. We all know Rome was not built in a year, so it does take time to do that. Our process is always ongoing, and one of the things that we've had to learn is that partnerships and collaboration with city departments is critical, and it really encourages cooperation, as well as constantly doing our education and outreach. So when we have our training, we try to talk about investigations, we try to educate people about it, because it's important for people to know that the work we do is really important. As far as accountability to the governing board, because I think that was another question from the task force, the ethics office is accountable to the governing board, the city of Atlanta, and the public due to the critical nature of our work. So just to be clear that we are accountable to all, three of these bodies. So we provide detailed reports on investigations and our activities to our board, and we do comply, and that's done once a month, and we do comply with a city charter mandate where we're required to produce an annual report, and that report is made available to the mayor and city council every year. And it really just details all our activities over the year, and it's posted to our website. Final thoughts. So final thoughts, because I do understand that, this is part of the task force's responsibility to look at some legislative revisions. So on behalf of the ethics office, what we are respectfully seeking is restoration of the Board of Ethics as its oversight board. For those that may not know, prior to the establishment of the Office of Inspector General, the Ethics Board was a standing board and reported to a Board of Ethics, consistent with best practices throughout the country. The current structure that we have is not consistent with best standards. We believe that the functions of the Ethics and Office of Inspector General are different and distinct. Furthermore, we believe that the Ethics Office needs to be independent and autonomous, and therefore have its original oversight authority. And we've gone through 4 years of this process. We've given it time, and we believe that it's not an efficient and effective structure, because you cannot have two agencies such as ours, two offices such as ours reporting to one oversight board. We've had administrative and operational challenges, which I can't get into right now in the interest of time, but this is not the best practice. And if you look at other jurisdictions, is not a structure that's set up like this. Furthermore, we think the public interest is better served with separate oversight functions. We have employees and public are still confused. They think we are the same office, and we're not. We have two different functions, two important different functions, but nevertheless two different functions. And we also believe there's a potential for a conflict. The reality is that the Ethics Office could investigate employees in the Office of Inspector General, and vice versa. The Inspector General could investigate employees in our office, so it raises a serious conflict and potential conflicts and tensions between the two offices due to this oversight structure. So we would respectfully request that the task force consider this as a serious concern on behalf of this office. And that concludes my presentation. I hope I stay within the time limits, and I'll take any questions that the task force may have.
I have one to begin. Could you just give a quick outline of what you would like to see it be, how you want the ethics board and the ethics officer and the OIG, how you think that would best function? Just an outline or a diagram in your.
Well, I think the outline would be that the ethics office,
Right.
it would be the ethics board,
Right.
similar similar to what it was before. We had an ethics board, and the ethics office reporting directly to that board, and we had our staff. And of course, and I can't speak to the Office of Inspector General, but they would have their own oversight function, or oversight authority, yes.
Where would you think the OIG should report?
I can't speak to that, Madam
Okay,
Chair,
okay.
sorry.
Thank you.
I have a question. Is a practical matter, I know you kind of talked about structurally how there's overlap or seemingly overlap between the OIG and your office. But as a practical matter, can you give us some examples of things that you've seen in investigations or without revealing confidentiality, if that's something that would cover those types of examples so that we can better contextualize some of the challenges that you're facing?
Thank you for the question. So our jurisdiction is limited. It's just, our jurisdiction is limited to conflicts of interest, gifts, and those things. So for example, the OIG may be looking into an allegation of corruption, and employees may think that our office is investigating. And so we have confusion, and I would say maybe vice versa, the OIG may have that same issue. So I think it's important to have that clarity so there is no doubt or question what office is investigating what potential violation. And for another thing is that our office issues final decisions with sanctions. It's my understanding that the Office of Inspector General does not do that. They issue recommendations. We actually have an actual decision where we have to, issue a sanction, actual write a decision, which could potentially be for the governing board.
Thank you. Good afternoon, Beth. Can you just tell me a little bit about the role of the governing board as it relates to your work? What do they do? What are your responsibilities as it relates to them?
So the governing board is our oversight authority. So in terms of the ethics office, we prepare our monthly status reports, which we have to present to the board. We present at the board meeting, a live briefing. More importantly, as the ethics officer is hired, can be hired and fired by the board, so the governing board. So my direct responsibility is to the board. But in terms of, I'm not sure if you're asking to day-to-day or just the oversight.
Both.
Well, to that extent, I won't say the board, because, we don't have a micromanaging board, which is great, but they are for the most part aware of our activities, not to mention, if we have an appeal of a case, we have to present it to the governing board. So if an employee appeals the case, it now is in a hearing before the board.
Okay, and so what is the difference between, in your mind, the ethics office being under the ethics board and the ethics office being under the governing board as it stands right now? Why are you asking that to be changed?
Well, I think for one thing, the functions of the two offices are different. We have different functions, and I'm not sure that, I just find that some of our meetings can be disjointed because we have two different mandates, two different offices. And I don't necessarily think that there may be members of the board, I may be speaking that may not be really, may not have the oversight or the background to deal with ethics issues and vice versa. And there may be members on the existing board that may not necessarily have the background to deal with, the Inspector General issues. And again, it's just not best practices. We don't see any board like this.
So there are no other boards, ethics boards, in your survey of other jurisdictions that report to, that have a similar reporting structure that we have in Atlanta?
No, not at all.
Okay.
No, it's not at all.
Okay, and then just a couple other questions. Does your office have written policies and procedures?
Yes, we do.
Okay. Are those publicly available?
We can provide them to you. We can provide them to the task force, absolutely,
Okay,
yes.
thank you. And I just have a couple more questions about sort of the procedures for investigations.
Yes.
Okay, we are at time, I'm just saying. Are we
Yeah.
at 5 minutes? Okay, because I know Judge Dean wants to ask a question. No, that's fine, I'm just saying. Go ahead, but we'll have to.
I defer.
Okay.
I have
Yes.
have a similar question
board, your board, the current board, does it have input into the investigative process as it's taking place? Or is it only an appeal or a review?
It's only an appeal, no, they do not have any, impact in the investigative process, no. So the only time they would come in is at the appeal stage, if there's an appeal of the matter.
And if I might, what is the practical effect on your work of having a single board? Are there times when you can't get the kind of oversight that you need?
I mean, I want to be very thoughtful about this. I won't say that, I just think that it's not the attention I think that the office deserves, because we have two separate functions.
Thank you.
Okay.
And that's just, I'm sorry.
Sure.
Thank you. I just want to ask some investigatory questions. Does your office issue subpoenas?
Yes, we have the authority to issue subpoenas.
Can you tell me how that process works?
Well, I may have to, if Madam Chair, so we have not issued subpoenas in a while, but essentially we cannot subpoena a person. We would subpoena more or less documents. So if there are documents that we needed, we would have to write out the subpoena and deliver to the individual that might be the subject, the documents that we need. If they do not respond, or if they decide they don't want to, answer, they want to appeal the request for the subpoena, they can appeal to the governing board.
Okay, and the subpoena, now you just help me a little bit understand this, because my experience is in the court world.
Okay.
Are your subpoenas issued pursuant to a court, or because as prosecutors, for example, you can only issue a subpoena if it is pursuant to a grand jury investigation, or you have court authority to do it? What is your authority to do it?
So our authority is through the city charter, where it empowers the ethics officer and the inspector general to issue subpoenas. So we don't have to go through a court order or anything.
And is there any independent review of the use of your subpoena power other than appealing to the governing board?
Not that I know of.
Okay. And so are there other jurisdictions, is this common in ethics offices, that ethics offices have the ability to issue their own subpoenas?
So I would probably need to research that before I misspeak, because I'm not absolutely sure as to that point.
Okay. And then as it relates to, you described that you give employees you advise them of certain rights that they have, if you will, and permit them to have a representative present if they want to. Is that correct?
That is correct.
Is the form that you provide, I guess the rights that you provide to employees, is that written?
Yes,
So do you give the employee that form prior to the interview?
absolutely. And investigators go over that form with the employee.
And then if an employee decides not to cooperate, for example, what happens then? What's the penalty for that?
And again, I have the deputy ethics officer, so if I'm not responding, if an employee, we haven't really had that many situations, but if not, we just end the interview. We may document in the report, but we'll just let them know that, well, we're gonna have to document this in the report.
Okay.
We're gonna have to wrap.
Okay.
Yeah.
Okay, all right, thank you very much, I appreciate it. Would
Thank
call
you.
the next person? Thank you.
Next up, we have the Ethics Board's Chair, Lai Hines.
Good afternoon, everyone. Thank you for inviting me to speak on behalf of the governing board and myself as Nicole Hines as the chair. Just to give you a little background on myself, my name is Nicole Hines. I am the League of Women Voters of Atlanta Fulton County's nominated me in 2016 and again in 2022. I serve as the chair for the governing board of the Inspector General Ethics Office since 2020, and am one of 3 current board members who presented during the crafting and discussion of Ordinance 19-01729. In my following following presentation, I will present my concerns and challenges that are currently in the ordinance and the recommendations by the mayor's office and city attorney. Just to give you a brief timeline, 2019, as vice chair of the board, I spoke to the committee on council during public comments about the need for independence of the ethics office at that time. I also expressed the concern that the board was stripped of its oversight and became just an appellate board. In 2020, as the chair of the board, I spoke again during public comments to full council, expressing the same concerns and presented to the committee on council. Fast forward to 2023, last year, the board, along with the ethics office and the office of inspector general, presented each retrospective changed their ordinance, as we have worked 2 years doing the legislation. As the vice chair, myself and the vice chair, we met with both the chief of staff, the senior advisor to the mayor, the then chair of committee on council, and council president to discuss these concerns. The biggest one that was one of our primary requests was mandatory report language, which was denied by committee on council to be changed in our legislation. This is the fundamental of oversight, and I will get into that later. Of this year, between March and of June, and then recently of September 13th, the board, along with myself, have met with the chief of staff and the city attorney, both present and past and present, sorry. We invited the mayor's office and the law department to present their concerns in front of the board twice. We even actually called a special work meeting. Both of those times, we did not have representation or presentation from those offices. Oh, there's a clicker, sorry. I didn't know I was clicking. Okay. It's just a clicker. There we go. Sorry about that, folks. Okay. So now with the challenges of the reporting of the financial reports, there's a lack of automatic reporting. If you go where I referenced the ordinance, those sections there, it basically says that the final report is given to those who investigate it, but it does not mention that the report comes to the board. This is where I said in 2023 was the fundamental request that we had asked for oversight, for it to be codified, that it actually has to goes to the board. That request was denied based on advisement from the law department, and more or less was asked to either put it in our bylaws or go through Open Records Act to get those reports. We are grateful that both offices have complied with our requests and do provide us those reports on a monthly basis, but I do feel that those should be in the legislation, that it should come to the board automatically without a request. As we talked about limited appeal of their authority, the board can only affirm or deny decisions made by Inspector General, but mostly the Ethics Office during appeals without any power to modify penalties, fines, or sanctions. This limits the board's ability to adjust outcomes in the appeal process, especially if the board sees it as maybe the fine is low egregious, or maybe the sanction or whatever's been presented to us in the appeal. But it's either we can deny it and affirm, and then it has to go back. So then we also look at potentially double jeopardy of that. Subpoena limitations. Same thing, with the Inspector General office may issue subpoenas during investigation. The board has no clear authority to enforce or modify subpoena-related decisions during appeals, further restricting their oversight capacity. The reference in the ordinance is at the bottom. During the last couple of months, we kept on hearing, where's the board, where's the board? So there's a lack of clear oversight in our current ordinance. While the section outlines the general responsibilities of the governing board, it does not establish a clear or consistent process of review, decisions, or investigation actions taken by either office if there is any type of non-compliance or ineffective actions. The governing board's powers extend to ensure that the Inspector General and Ethics Office operates transparently and effectively. There's a lack of enforcement authority. The section does not give the board the authority to enforce recommendations or compile city departments to act on findings from the Inspector General. There's a low response rate currently. Without explicit authority to enforce compliance, the board's role as oversight is limited to advisory capacity rather than active oversight with real influences. Once again, the reference is at the bottom. Challenges, board composition. Contradiction in lawyer requirement. The ordinance requires 3 lawyers to be on the board. Currently, only 2 of the nominated positions are required to have lawyers. The other 2 that does not state that they cannot be a lawyer is only basically they have an open nomination, which contradicts itself. So either everyone can have an option to have a lawyer on the board, to have 3 lawyers on the board, or the wording should be 2 lawyers because of Gate City and the Atlanta Bar Association, or the State Bar of Georgia. And then once again, the reference in the ordinance is at the bottom. The concerns that we have with some of the approved, that's been coming from the mayor's office and the law department is the pre-approval investigations. Requiring board approval before investigations contradicts the Office of Inspector General's OIG's core principle of independence. It allows external parties to potentially influence or delay investigations, compromise the objectivity and timelessness of investigative processes. It jeopardizes confidentiality. The requirement risks exposing sensitive information about investigations prematurely to additional parties, making it harder to secure confidentiality, which could deter whistleblowers or allow people to come forward. On top of some investigations are frivolous and no foundings are put on board. So now we have people's names or issues coming in front of a public meeting that could jeopardize their livelihood. Once again, references at the bottom. Another concern I realized that was a request or that came from was the chairperson's qualifications. There's been a request to put in that the chairperson should be a lawyer with 10 years of experience. As I stated before, we only have currently 2 required attorneys on the board. This makes that anyone who is not a lawyer but is a qualified leader could never be the chair of this board. Also, it puts basically 6 or 7 people never ever having, along with those nominating bodies. I know we have a lot of attorneys on this board, and no disrespect, but being an attorney does not mean you're a great leader at all times. And you might not want to be a leader. You might just want to be, hey, I want to participate. So that also is reason why it does not ensure leadership. I've been on this chair, as I stated, for almost 4 years. And there are so many moving parts of just managing the board, managing the offices, and also making sure that we are upholding the integrity of our ordinance in our city of Atlanta. So it does narrow the potentials. In my conclusion, I do want to uphold transparency, accountability, and independence of the Office of Inspector General, Ethics Office, and the governing board. This is to preserve the influence from the executive branch. Improving city policies and procedure is crucial to ensuring accountability, but mostly allowing the Inspector General and Ethics to do their job. Legislation already aligns with best practices, granting necessary access for investigations, but consistent training across all departments, including the mayor's office, is essential for fostering ethical compliance and forgiveness. I put that last one there because our meeting on September 13th, it was stated that the board did not have clear legislative changes and that we just wanted training. We have had 20+ years of understanding what the Ethics Office does for the city of Atlanta. We've only had 3.5 years to understand what the Inspector General can do for the city of Atlanta. Our board had recommended that we do some type of lunch and learn or roundtable discussion with actual Inspector Generals that do the job day to day, so we can understand how does these processes work, so that we can make sound judgments on policies, procedures, and legislative changes. That concludes, and once again, thank you for allowing me to present.
All right, thank you very much. Questions? Are all these materials, they've been submitted?
Yes.
Okay, very good, thank you. Questions?
I do have a question, Madam Chair, thank you. Does the board itself, I did see online that the board had bylaws and the board had, what do you guys call it? Call it leadership policies or something like that?
I mean, we definitely have bylaws.
Okay. Do you have definitive policies and procedures that dictate how you do your job?
No, not currently. We mostly put all of it in our bylaws as we look at the bylaws as our functioning structure of the board, i.e. meeting, when we meet, how we meet, what should be presented, how we vote on certain things. So we do put that in there, like what's a quorum consistent.
Okay. For example, part of your duties are handling appeals. Is there some procedure that, any standard SOPs that dictate how you handle appeals?
Not currently, not in our bylaws and not from the board. Typically, we do have it where every other month it's set for appeals only, and that is in our bylaws. And from there, we allow the ethics office or for the Inspector General to present any appeals that have come through their office, and we listen to the appeals and ask our questions.
I have one more question, Madam Chair, and then I'm gonna have to submit my questions in writing because there's not enough time. Do you have copies of both the IG's SOPs and the Ethics Office's SOPs?
Not probably incomplete. I would definitely say, I would have to go back to my emails, but off the top of my head, I don't think we have every single SOP.
But there are SOPs.
There are some, yes, they do have some policies and procedures that I know of, yes.
Okay, thank you.
Thank you very much. Any other questions? Any other questions? Representative, there's a little more time. Any more questions?
Oh, okay. All right, so, thank you. I tried to turn it off so you didn't hear my, are you familiar with whether or not other jurisdictions use a governing board as sort of the authority over inspectors general's offices?
Yes, I do understand that there are some boards throughout the country that do use Inspector General boards. They are not, from my understanding, they're kind of still oversight, but it's not a checks and balance. I might be saying the wrong wording in there, but I do know there are other boards.
Okay, have you looked at those other boards and how they function over OIGs under their jurisdiction?
Briefly, not in depth yet, but yes. In terms of what we do and how we function as a oversight board, somewhat aligns with what I've noticed with other IG boards. In terms of there's no going to the board for requests to do investigations. There's no going to the board for any of their operational procedures, right? It's kind of like how we do it currently, where they come to us, they come to us to report out, but that's about it.
So what is your can you just tell us in your words what your oversight function is over the Inspector General and then over the Ethics Office?
In my own words, our oversight is, we do go through making sure that they are spending their money correctly, so there's nothing outside of that. With our request of the reports, we do go through the reports. We do talk about what's been open, what's been closed, from both offices, so that we can kind of see if there are any patterns, especially if there's a certain area or certain department maybe are having some issues, and if there's oversight, meaning that they are not pursuing or, not saying right now, but that's what we look for. We look for patterns with those open reports or closed reports. We look at patterns of how many cases actually hit each office. If it's gone up, if it's gone down, which means that, hey, is the hotline working? Is the walk-ins working? Is that what we're asking people to do, report, issues? So we look at those patterns. We do talk through some of the findings that they have, especially when it comes to the IG's office, and we look at iPro. There's a lot of conversations about the contracts, what flags it, how do they go through it. So we kind of really dig deeper into the reporting. If
I
that
think
makes sense.
Mr. Brothers has one last question.
So I understand your point on pre-approval of investigations, but what about sort of overall scope of the investigative authority for the IG? Does the governing board in any way approve sort of overall scope?
We go based off of what the legislation says. The legislation does state that they should have access, full access to the information that they need to do their investigation. So we do follow that. We don't overstep that based off of the legislation, if that's what you're asking.
But in terms of what types of matters are in scope for the OIG to investigate, does that get discussed at all?
No, nothing of if it's an open investigation, it is not discussed in open meetings.
All right, thank you very much. Thank you very much. All right, call your next presenter.
All right, next up we have Office of the Inspector General, Lorenzo.
afternoon. My name is Shannon Manigault, and I lead the City of Atlanta Office of the Inspector General. I've been given a limited amount of time here today to address a great many issues facing the Office of the Inspector General, so I want to take a moment now, before my time runs out, to thank all of the employees of the Office of the Inspector General, many of whom are here today. It's the members of this team who've had to work through a number of roadblocks that have been put in their way as they've been trying to do their work. And it's the members of this team who've had employees who were initially cooperative tell them, well, I was now told not to talk to you. And so they've had to work doubly hard to gather facts. It's also the members of this team whose professional integrity has been intact as they've carried out these duties in the same manner as anti-corruption professionals in offices of Inspector General across the country. So I want to thank you all personally. And I also want to thank them on behalf of the countless city employees who want our office and need this office to stay around and stay effective, and who would show their support outwardly, except they are in fear of retaliation. These are employees who have come to me and to other members of our office and have said, you don't know how many of us are behind you. Please keep doing what you're doing. So thank you to the staff of the Office of the Inspector General for all that you have done and will hopefully continue to be allowed to do for the benefit of the city. Our office has provided additional background materials to the task force and received by email, and there are also supplemental binders that you might have by now. I understand that they'll be added to the task force website, as explained earlier, but briefly for the members of the public who might be watching, OIG has provided informational slides, these are the slides that are on the screen now, providing background information about the work of the office. It also outlines our concerns and legislative needs, and it responds to some of the issues that the mayor's office has raised with council in support of the legislation to create this office, this task force. In addition, we provided a chart at the request of one of the task force members, Councilmember Shook, who I'd met with before the task force was actually assembled, in order to discuss legislation that would help OIG perform its function. The chart details concerns that have been raised by the mayor's office and some members of the council, and it outlines practices in New York City, which was a request for Councilmember Shook, but also in Chicago and here in Georgia, in the state of Georgia Office of the Inspector General. This is an important document because it underscores two significant points. First, that the way the Atlanta Office of Inspector General has been operating is consistent with how other offices of Inspector General operate. And second, that these other jurisdictions have the kind of access to records that the mayor's office has denied the Atlanta Office of Inspector General. We've also provided a copy of the report of the Task Force for the Promotion of Public Trust to provide some background about how it was that Atlanta arrived at the conclusion that it needed an Office of Inspector General, about the benefits of an Office of Inspector General and all that it would bring for the city, and about the tools that it would need in order to get the job done. The task force arrived at these conclusions after spending 5 public meetings over 5 months, and after receiving testimony from the city's then existing oversight entities and from all members of the public who wish to offer their perspectives on this significant issue of combating corruption in Atlanta. And they also heard from subject matter experts, a municipal integrity expert for the Center for the Advancement of Public Integrity, and from 2 sitting inspectors general from Baltimore and Philadelphia. So obviously these are things that the chair is aware of, having chaired that task force, but wanted to provide some foundation for the rest of the task force members. We've also provided a copy of our 2023 annual report so that you could have an accurate snapshot of the work of the office. And finally, we provided a position paper that was issued by the Association of Inspectors General, which we learned earlier that the task force has not heard from, but has had a submission for today's proceedings. The AIG position paper is also important to some of the oversight questions that have been discussed, as it offers guidance regarding appropriate oversight for an Office of Inspector General. You'll note that the mayor's proposed actions regarding Office of Inspector General and its board run counter to the best practices recommended by this leading association for state and local inspectors general's offices. I'd like to spend the remainder of my time talking about employee rights. The mayor's office has cited the protection of employee rights to justify both the formation of this task force and also some of the reform recommendations that it's proposed. The background slides that you've been given correct the record and dispel some falsehoods that have been fostering fear-mongering surrounding employee rights. The short story here, and you'll see more in the slides, is that we've never searched any employee's personal equipment, cell phones, or bags. We have never denied an employee a personal attorney for an interview. And of all of the many interviews that we've conducted in the office since 2021, I believe there's only been 2 instances where we've approached interviewees at home unannounced. Both of those instances took place during regular business hours and where both the employees were working from home those days. But what I really want to talk about is the employee rights that actually have been compromised. And that's happened as a result of the system that the mayor's office has established in order to provide OIG access to records. This system promotes the disclosure of the identity of witnesses and subjects of investigations, where we, in the Office of Inspector General, hope to protect employees and investigations by keeping the circle of those who know about an investigation as small as possible. The mayor's system, however, exposes the existence and the content of investigations to an ever-increasing set of individuals. We actually had an instance in August where a request for one file, one personnel file, including personnel evaluations, performance evaluations, and disciplinary records, was sent to one city employee who we believe possessed the access and authority to provide that file. But given the system that's been imposed by the mayor, that request was then forwarded and forwarded and forwarded again by email, so that ultimately an additional 19 individuals were included on that request, including the subject of the investigation. This system of disclosure is absolutely not in the protection of employee rights. In closing, we hope the task force can help bridge the gap to address any of the legitimate concerns of the mayor and the council and the expressed needs of the Office of the Inspector General so that it can be effective. But we also want to flag for this task force and the public the inherent danger of allowing the mayor and other elected officials to interfere in the work of the Office of Inspector General. Many aspects of this task force, from the way that it was formed by legislation, walked into committee, passed, and then passed through full council within roughly 5 hours with no notice to OIG or the public or any other involved parties, to the way that it's staffed by mayor's office leadership who have a stake and a plainly articulated point of view regarding the Office of the Inspector General, to the timeline that the task force has been given to complete its work, which, as stated in the last task force meeting, renders absolutely impossible the having of a full and fair public examination. All of these aspects show just how easy it is for elected officials, including those who have been the subject of OIG investigations, to act against the Office of the Inspector General. The Office of the Inspector General is designed to be independent. As this task force considers reform, we hope that it is mindful of the potential harm to the public if the mayor is allowed to interfere in investigations and reviews and the manner in which they're conducted. And during public comment in the first task force meeting, Dr. Jerry Newpark implored the task force to keep the best interests of the city in mind. Not the interests of the mayor, not the interests of the council, but the best interests of the city. Now, the benefit of having an effective, independent Office of Inspector General is that working for the best interests of the city is what we do every day on every matter. For us, it is never about who might be embarrassed or offended for the work. It is never about whose family or business relationships might be impacted. We have no stake in any outcome. We must only fulfill our professional responsibility to prevent and detect fraud, waste, abuse, and corruption for the benefit of this city. In our short time as an office, we've only ever conducted our work and reported our findings with these ends in mind, and we want to continue to do so. We ask that the task force consider the additional resources we would need so that we can even better serve the city. Thank you so much, and I'm happy to answer any questions.
All right, thank you. Questions? Mr.
So, yes, the same question I had for the prior person about scope. So you described fraud, waste, abuse, and corruption. Would you view that as sort of the scope of your investigative mandate?
I would. So the idea is that we should be preventing and detecting. So if we largely receive complaints, and most of our investigations are complaint driven, the charter also allows us to initiate investigations where we feel that there is reasonable articulable suspicion. So for translating for us, it means that if we think that there's some significant risk to the city there, then we can conduct an investigation in that way. But overwhelmingly, our investigations are complaint driven.
So would there be certain issues that maybe would come in, someone would raise a concern, we could say, yeah, that's outside the scope because it relates to some sort of minor issue, or maybe something better served, investigated by, say, the law department as compared to the OIG?
All the time.
Okay.
So we make what are called external referrals. So if there's a matter that comes to our office that we think would be better addressed by another party, sometimes that involves parties that are inside the city, so we may make a referral to the ethics office. It could be to the Department of Human Resources or law department, depending upon the issue. We will also very frequently make external referrals to county or state entities. So someone comes in and they're complaining about benefits, that's something that happens all the time. What we endeavor to do is be of service to anyone who calls. So as much as possible, if we can point them in the correct direction, we'll do that.
Thank you. That's all.
Other questions? Okay.
Good afternoon. Do you have written sort of policies and procedures?
We do. We're a new office, and so some of those things are still being developed, but one of the first policy procedures that we established for the office was the commitment and adherence to the Association of Inspectors General Principles and Standards for Offices of Inspector General, the Green Book, which I know that you all have been provided. So the adherence of all of our employees to that standard serves as a foundation for the work of the office. We also then have additional policies that we have created for the office, and many are still in the works as we build out the infrastructure for the office.
Okay, so just a couple questions about that. Are those policies in one place together where your employees have ready access to them?
Yes.
Is it one document, or is it sort of the Green Book plus a position paper on this or that and the other?
So everyone, all employees, when they start, get a copy of the Green Book and a number of other background kind of foundational materials for the office, including the charter and other things that people should know. But that's separate from our policy manual. We have binders that each employee has, and so as we are then developing additional policies, we add to that binder, but they all have that. We have attestations that need to be made on an annual basis as part of that policy, so everyone has them.
Okay. Now, are your policies and procedures available to the public?
So no, but we've been working, it's one of the things that we've been reporting to the board on developing a public-facing policy and procedure manual that will kind of address some of the probably most common questions that members of the public might have about the way that we conduct our operations. I know that this is a tack that is taken in other jurisdictions. The city of Baltimore has a public manual, and we like the idea of that, and so we've been working on developing it.
Okay. And are you working in conjunction with AIG, or is this all internal?
All internal, though it's still with the kind of guidance and training from AIG. So I have a certification as an Inspector General from the Association of Inspectors General. So do each of the deputies in the office. So do the overwhelming majority of the investigators and auditors in the office hold those certifications. So we receive training and we receive guidance. But in large part, the policies and procedures that we have been developing have been based on our experience from both kind of us in our offices, our prior kind of work experience and bringing that to bear, and also from the policies and procedures from other jurisdictions, because one of the benefits of having a new office is that you don't have to just take what's been there for 50 years. You can kind of look around and pick and make sure that you are taking what is truly the best practices from across the country.
Okay.
The time is up, but if you kind of ask one more question.
Well, I did want to just get an understanding of your office's relationship in your mind, or from your perspective, to your governing board. What authority does the governing board have over your office as you understand it?
Sure. It's not different from what our board chair has described and also the ethics officer described in terms of the work. We issue subpoenas, and so the board is then there to hear any motions to quash a subpoena that we've issued. So that in terms of our work. We have regular reporting to the board bi-monthly and sometimes in between, depending upon the issues that arise. Their review of our report and our work is to make sure that we are kind of staying on the path, not going off the rails. And that is the nature of kind of general limited supervision that's appropriate for a board for an Office of Inspector General. It's not to be involved with day-to-day operations, but rather the real kind of power and authority and what helps the kind of establish the independence is the board having appointed a qualified, trained professional to run the office in its day-to-day, and also to make sure that it can remove the leader should any significant issues arise.
Okay, Mr. Brothers, one more quick question.
Got it. So the position paper from AIG was really helpful. And there's one section where they kind of raised the helpful question, who provides professional oversight of the IG, and what they suggest is that from time to time, external peer review or accreditation for compliance through a review by AIG is appropriate. Has that ever happened?
No, we're so new. So we have been working towards getting to the point where we will have peer review, because that's exactly what we want to do. We want to make sure that we are doing everything in compliance with the appropriate standards nationwide. And the Deputy Inspector General who runs our investigative division comes from Florida, which is the land of offices of Inspector General, where state certification is actually required. So that she actually had responsibility for getting her office in shape for certification there. So every day we're working to make sure that the office can be in a position to survive and sustain that kind of review. But the hope is that we get there, and then there's periodic review.
Okay, thank you very much. We appreciate it.
Thank you.
Call the next presenter, please.
Next up, we have the Human Resources Commissioner, Mr. Calvin Blackburn.
Good afternoon to Madam Chair, Chief Justice Ward Sears, messing up all the time, and other members of the task force. I'm Calvin Blackburn, the Interim Commissioner for the Department of Human Resources, and I wanted to speak about, don't want to have a formal presentation, but I wanted to speak briefly about my department's involvement with the Office of the Inspector General since I assumed the role of interim DHR Commissioner. I should let you know by way of background, for the past 4 years, I was an attorney with the city's law department and assumed the role of interim commissioner of DHR in July of 2024, I guess, so just a couple of months ago. One of my first meetings, however, when I got there, was to set up a time to meet with the Office of Inspector General, the helm of that office, Ms. Manigault, out of respect for her mission and out of respect for the importance of the work they do, and we wanted to sort of find how we could assist her in that work. And the main goal of that meeting was to try to understand their processes and procedures and how our office could, work with them in that regard. And we had a very, to Inspector Manigault's credit, we had a very fulsome, open, honest, and thorough discussion. I may say a sifting discussion. And the discussion really boiled down to this tension. How does the Office of Inspector General accomplish its mission, but at the same time not infringing upon the rights, privacy, dignity, reputation of those involved in an investigation? And I know we have some attorneys on here. You will not be surprised that we might have differed as to where that line is drawn. So I want to let you know those discussions are ongoing, but I'm here to let you know that our office, Department of Human Resources, is here to work together with OIG, and to the extent that the law permits it, to cooperate and provide whatever resources, information they need to complete the job. And so that's why I'm here. Any questions? Happy to answer.
Any questions?
Thank you. Can you tell me what the city's policy is on obtaining city-issued phones and city-issued computers from employees for purposes of investigation?
Oh, that I would defer to the city's law department on that one.
Okay.
I know that I wouldn't want to speak about that without having clear understanding what the city's position, law department's position is. As you know, there have been concerns about that, so I'm not aware of the specific policy. That policy obviously would track whatever the law is about that, and I would defer to the city attorney's office for that.
Okay. And what are employees told, if you know, their rights are in connection with being a witness or a subject in an investigation? What are they told? Are they onboarded during the process of being hired? Is there some sort of instruction to them about cooperating with investigations or anything like that?
I haven't sat through a full onboarding to know if that specifically is brought up. I would certainly believe that we would always encourage any of our employees to cooperate fully with any request from the OIG. But as far as whether we specifically address that in the onboarding process, I can't speak to that. I'd have to look. I don't know if it's addressed or not. I don't think we have any of our folks here who participate in that part. So I don't know specifically answer that question. But our policy and practice is always to cooperate with the OIG to the extent allowed by law. And we take guidance from, of course, the city attorney's office.
Okay, I guess I was looking for notice given to employees about what is expected of them and what their rights are in connection with these various entities within the city who might be conducting investigations. Where does that happen?
I would have to, I'm sorry, I know your name. I'd have to sort of get that information for you. I don't know where it is, but I'd be happy to respond to that in writing.
Yes, sir.
I checked my team.
Thank you.
Thank you.
Mr. Dell.
So you highlighted a difference of view between your office and that of the Inspector General. Is that view, was that derived from your policies versus the OIG policies, or more an opinion from your office versus the OIG's opinion as it relates to employee rights?
Well, I will confess I've been a practicing attorney for 27 years prior to, joining the Department of Human Resources. So really what it came from was the hue and cry that I heard once I joined the department of employees who felt that their rights had been abrogated or violated as far as the visits to their home, the computers confiscated, phones confiscated. Some have said they weren't allowed to talk to the attorney. Just some of those things I heard that were concerning. So I don't know if it was necessarily a battle of my view versus the OIG's as much as a difference of opinion of maybe where the law draws the line as far as how far the OIG can reach. Can it get to these items in the way that it has been getting to them? So it's, I believe there's gray area there. What the Inspector General and I we're having is just kind of a discussion of how do we operate within that gray where they're allowed to get the information they need, but privacy rights, dignity, reputational protection, and interests aren't abrogated. So again, but at the end of the day, we depend on opinions from the city's law department to lead us and guide us. But that was, as I joined the helm 2 or 3 months ago, that was what I heard from those employees who had experienced that before I arrived.
Okay, you'd like to see this gray area either made black or white, or how would you, so?
Yeah, I think so. I certainly want to make black or white on some black letter law, if you would, and just make it clear sort of where that line is. I think right now it's sometimes unclear, and the real concern is for employees who might not be as, how would I say this, not as aware of the law as I might be, and what their rights are when someone shows up at the door and during business hours and demands something. Yeah, I think we would want around some bright line guidelines. I think that would help everyone involved.
I just had, oh, no, I just had a follow-up
Okay.
question. Thank you. So in terms of your discussions with employees, we've heard and received submissions as it relates to the fact that the devices that were sought after were City of Atlanta devices. We've also heard that they may be personal devices. Specifically with the employees that reached out to you, was it public or private devices that were seized or attempted to be seized by the OIG?
I would hesitate to speak. I've heard discussions around both, so I don't know the answer to that. I would hesitate to give a definitive answer one way or the other. My general understanding was that these were city devices that were sought, but I think there are people here, possibly from my department, who had direct experience with that and may be able to speak to it. Again, this happened before I arrived, so a lot of it I heard, no pun intended, hearsay, and some people just sort of spoke to me about it, so I didn't have any specific evidence about what it was. I just know that in some of these cases, employees felt like their rights were infringed upon, and they really didn't know what to do, and they were kind of, overwhelmed or surprised to be visited in the manner they were. But to your specific question, were they personal or government-owned phones, or both? I hear that they were city-owned phones, but I'm not sure that excludes personal phones. Well, I just don't know, but I hear that they were city-owned phones.
Okay. Oh, one more question, please.
Just briefly, sir, at the outer limits of what you would understand the employee's rights to be, are they permitted to simply refuse to cooperate with an investigation?
I would hesitate to offer a legal opinion. I think what the approach is now, that we ask employees who are contacted by the OIG to reach out, just inform our city attorney, I believe, about it within, and that they respond within, I think it's 2 or 3 days. So I don't know that we've directed anyone to just not cooperate. I don't think that's a part of, unless of course we felt like the request was violative of the law. But I'm not aware of any instance where we've had a policy saying don't cooperate.
No. My question is not whether you've directed it. I'm simply asking whether the employee has the right ultimately at the outer limits. Do they simply have the right to refuse to cooperate with one of these IG investigations?
I would defer, again, sorry for Dodge, I would defer that sounds ultimately like a legal question. Unfortunately, I defer to the city attorney's office for that guidance. I would hate to have time
So I
to
guess
hear
that's
that.
somewhat of a follow-on, because in the materials we received, tab 29, there's a city employee voluntary interview warning. And it says really clearly, you're being asked to provide information, it's voluntary, you don't have to answer, no adverse employment action if you don't answer, and anything if you do decide to provide the information, then it can be used. I mean, are you suggesting, or is anyone suggesting that people are not given this warning before their interview? Because it seems pretty clear to me that they're informed if this document is being used to tell them what their rights are.
Well, I think it's a difference between someone who's a witness as opposed to someone who's a subject of investigation. Are you referring to like the Garrity warning or which?
It's called the City Employee Voluntary Interview Warning. It's a document that looks like it gets provided to the witness before, they're interviewed.
It looks like something similar to Garrity.
Yes.
Okay.
Yes.
I know we're probably asking stuff beyond your purview.
Yeah, I took off my legal hat. I was, city attorney sent me over to DHR, so I try to refrain from legal opinions at this point, but
All right. Thank you very much.
thank you very much.
Next, are these clocks working? I can rely on?
Yes.
Okay, thank you.
So next up, we have the Director of Emergency Preparedness, Mr. Felipe Denbrough.
Good afternoon. Make a statement or you guys ask me questions?
You make your statement and then we'll ask you questions.
Okay, I've been in this job for about 5.5 years. Before that, I spent 23 years at the FBI, so I'm very familiar with investigations regarding progress and abuse and investigation of public officials. So as such, I want to go back to something I learned in Quantico, that Jay Garbuba stated that we're a fact-gathering organization only. We don't clear anybody, we don't condemn anybody. Why tell you that? In my instances, and in full transparency, I must say this to you. My wife applied for one of the jobs in IDIG. I don't know what happened to that because we cannot have a Chinese wall on that. So I think you must know that on transparency. And number two, I've been the subject of an ID investigation dealing with the warming centers. So I'm putting that, for a matter of record. So at the end of the day, one of the things that we need to, or the panel needs to come to, or the area for concern that we have is some of the requests that my department has received, because I oversee the security offices, everything dealing with security for 220 facilities in the city. They asked me at one time that they wanted access to executive offices, the executive branch, legislative offices, and pretty much carte blanche as to city offices in in the city of Atlanta. So that's why I'm here. If you have any questions, I'm ready to answer.
Mr. Dove?
Were those requests subject to any sort of subpoena or?
No subpoena.
Mr. Dean, is your light on or did you just forget it?
Oh, I was using this one.
Representative Miller? Yes.
Okay, so I just want to make sure I understand what you just said. One of the concerns that you said you had was that there was a request for access to every executive office and every legislative office?
Yeah, to access to the building, to their offices.
Okay. And that came from who?
The ID?
And what was the response to that request?
I nearly went to the city attorney and to the CEO.
And what was the result of that?
Don't know anything about that.
When was this request?
Sometime last year. I have to go on my record.
Thank you.
Any further questions?
What was the scope that was being asked to have access to the offices? Was it to come in to search or?
That couldn't, I remember when you were in the U.S. Attorney's Office. No, sir, I don't know the scope. So any answers to that, I would be, I have no idea. But the fact that they have such a broad scope, it poses legitimate issues with the separation of executive power, legislative, and anything that encompasses as such.
Any other questions? All right, thank you very much.
Thank you.
On the next presenter, please.
Next up, we have the Department of Customer Service, ATL 311, Ms. Maisha Good. Doesn't look like she's present. Move forward.
So I would just go ahead and go.
Next up, we have Deputy Commissioner of City Planning, Mr. Greg Pace.
Good afternoon. Correction, I'm Gregory Pace. I'm the Director of the Office of Buildings. I'm not the Deputy Commissioner of City Planning, which resides in the
We will note that in the record.
Okay. Thank you.
Okay, my name is Gregory Pace again. Good afternoon, thank you for having me. I am the Director of the Office of Buildings. My office, and I oversee permitting, inspections, and licensing within the city of Atlanta. I did answer any questions. I recently had to utilize, I solicited the Office of the Investigation General's office for investigative purposes to initiate regarding some improprieties within our office. So I've utilized them recently and can answer any questions you may have as well.
Any questions? We're not here, but of course, about that investigation. Okay. Any other questions?
I'm sorry, is there a limit on the questions?
Well, was it about the specific think you were referring to. We're here for the task force to process it.
Correct.
Okay.
Yeah, it was more so to, if
No,
there
you're
were
talking
any
about-
concerns, I mean, any challenges or concerns I may have had with, I guess, reaching out to them or anything of that nature. That process.
Would you like to share anything about challenges or concerns that you've had in connection with that?
In reality, the only, I guess the concern I had mostly was the length of time, but once the investigation was concluded, the depth of it, the detail of it, I understood why it took the time.
Any other questions? All right, thank you, sir.
Thank you.
Next presenter?
Next up, we have the Human Resources Deputy Commissioner, Ms. Kimberly Finley.
She stepped out to the hallway for a second.
Okay. Well, why don't we then go to the next presenter and we can come back?
Next up, we have Human Resources Deputy Commissioner Candace Cullen.
Good afternoon, Madam Chair and esteemed members of the task force. I'm Candace Colas. I am the DHR Deputy Commissioner for Compliance and Regulation. The offices that are underneath my purview are the Office of Labor Employee Relations, Office of Policy and Procedure, as well as the Office of Medical Leave. I was asked to speak about challenges or concerns that I've had with OIG, and this gets a little personal for me. But I want to start with gratitude. I am grateful to finally have the opportunity to have my voice heard and to provide context to an investigative report that was a gross mischaracterization of my character, both personally and professionally. I'm also grateful for the thoughtful way in which this administration is moving, and you guys are taking your time to examine everything that we can get to the best practices piece. I will say that I had serious reservations about standing up here today because as much as I'm grateful for the opportunity to clear up the incorrect conclusions in May's report, there was a lot of negative energy surrounding the investigation into former Commissioner Smith, which is where I was named. I don't want this to turn into an open tsunami of negative energy again. If I could tell you how incredibly hard it was for me to walk in the building every day for months after the report came out, it would be an understatement. It takes a long time to build professional reputation. You have one name, and we all work hard for it. And the way in which, and I apologize for my voice, I'm drinking water and having minutes, the way in which that was damaged with one report was honestly disheartening. It led to people being comfortable undermining the credibility of the Department of Human Resources. I've got this team that is incredibly hardworking. We've got over 100 people where every action that they took was called under question. It also resulted in people being comfortable going down to city council every other week and putting people's names in their mouth, saying things that are untrue about it, myself included. One is that I got fired from the Department of Law, which I didn't. As I'm going through all this, I'm a woman of faith, and I really truly believe that everything happens for a reason, and that the universe unfolds as it should. And I thought, okay, what's the learning point? This is a beautiful opportunity for learning. By way of background, I have practiced labor and employment law for 28 years. I know it's hard to believe because I'm only 35. Everybody not like that's true. The math doesn't actually add up, but for 25 years, I have taught organizations on how to properly do internal investigations. I've done over 1,000 workplace investigations in my career. Some of my clients include Coca-Cola, ConocoPhillips, Mercedes-Benz, U.S. International. They all use my investigative process. The governmental space, the state of Idaho, the state of Virginia, they all use my investigative process. The city of Atlanta uses my investigative process because the Office of Labor and Employee Relations, we have such a great, hardworking team of investigators. And even in the educational space, universities in the state of Georgia use my investigative process, and private clients like Woodward Academy prior to the pandemic when I had my consulting firm. I list those to let you know that it doesn't matter what type of entity you are, whether you are public or private, big or small or governmental, the process should be the same. It should be the same. When you investigate, you gather facts. You gather facts from all relevant witnesses. You weigh witness credibility and understand the context in which these allegations are made, and then and only then do you make findings. The OIG, with regard to the investigation I'm speaking about, did not engage in a proper process. They made conclusions without gathering all the facts. Now, it is my understanding that there were people who refused to speak with the investigation team from OIG. I was not one of them. I, in fact, was the opposite. This investigation went on for months. I have, and my calendar is up and ready. I took one vacation. While I was celebrating my mom's 80th birthday on the beach, I, like all the other hardworking folks in the city who rarely take an actual break, checked my email on Tuesday, and I got an invitation for an investigative interview in person on Thursday. That being said, I wrote back from my vacation and said, hey, unfortunately, I can't make this meeting. How about next week? I didn't hear anything. Unilaterally, 10 days later, I say, hey, has this matter been resolved? I'm happy to talk with you. I heard nothing. I didn't even know I was part of the investigation until I got the preliminary report and read it. In shock, just unbelievable, I sent a third email saying, hey, I'd be happy to talk with you. Some of the conclusions that you came to, if you had the evidence, emails, voicemails, if you talked to me, you would come to a different conclusion. I heard nothing back. So it is interesting to me that you have a witness that is declared unresponsive and written up as so in a report when that was not the case. It was especially disheartening because then, a day later after the report is published, we've got OIG standing up at people's houses, going to their homes to talk with them where they won't even answer an email from me. I think this is a learning opportunity, and I cascaded it down to my team, where now we require certain safeguards on when we declare a witness unavailable. My team, they have to reach out 3 times, at least in 2 different methods, and put that in the report as far as how they tried to be contacted. If they did talk to me, they would have discovered that I actually did follow the State of Atlanta's process when investigating the allegations against the respondent. I followed the process when an employee, who happened to be Commissioner Smith's daughter, came to the office suite at a wit's end and said, I can't take it anymore. Consistent with employee practice and process, I leveraged EAP. I reached out to them. They put her on a mental health leave of absence. She wasn't the only person I did that for that day. I did it for another employee as well. I followed the process and had the director of the Office of Labor and Employee Relations start an investigation. Now, keep in mind, there are 2 sides to DHR. There's an operational side, and then there is the investigative arm. This is specific and purposeful. Operations does operations. We try to keep ourselves objective and just make gather facts and make findings. Operationally, I was not the person who looked into the training allegations. I was not the person who had conversations with the solicitor about whether Bridget Smith was supposed to report into him. I know the report said I did, but I wasn't part of those conversations, and had they asked the right questions, they would have known that. Had OIG talked to me, I could have shared that I believe that Tamika Sperlings-Brooks acted consistent with DHR policy for the investigatory arm of things. She did all the investigatory interviews, and it was her that reported that 5 different people made complaints about this employee. Tamika Sperlings-Brooks was the one that asked me to attend Johnson's interview based off her reputation of being a bully. And then, had I talked to them, I could have provided them a voicemail with Tamika's own voice that said she was the person who decided that Ms. Johnson was to go out on paid leave, not me, as the report found. I could have provided context for the Jennifer Johnson interview and explained how very disrespectful she was to one of our team members. And yes, I did. I'm an attorney by trade, and I have not heard the audio tape, but I probably did cross-examine her and tell her that I was not going to allow disrespect to my team members. I stand by that. I don't like disrespect. I followed the process when I did tell Raines Carter, the solicitor, that I would not provide him a copy of the report before it was finalized, and would have understood had they talked to me. There was no special treatment, even for the solicitor. An open report is not shared. I could have explained that everyone agreed with Ms. Johnson's termination recommendation. That was me, Tamika Sperling-Brooks, Daniel Jones, Anthony Roberts, and Raines Carter. I could have provided multiple emails that indicated that Raines Carter thanked me for my cooperative and collaborative effort for this. There's a July email where he thanks me for helping him draft a termination letter, and a September email that said, and I'm going to read it so I don't misquote it, Deputy Commissioner Close worked with me in a patient and thoughtful way to arrive at her departure date and the transitioning of her duties. All of this could have been shared had they just talked to me. Beyond the facts they failed to collect, that would have provided objective evidence that contradicted their findings. They would have had the opportunity to weigh my character and my credibility.
About a minute left. I just
Correct. Thank you. To know that I take terminations very seriously, I would never put my bar numbers on the line. My team laughs because I say it at least twice a week. They would have known that Christy Johnson did not impede any investigation by not turning over responsive documents. Tamika Sperling Brooks never kept anything on her shared drive. She kept everything on her hard drive. She refused to return her equipment back to the city for 6 weeks. But we found the documents in her computer bag down in the basement, confidential files with her computer. So yes, we didn't obstruct, we were hunting for those documents. I started with gratitude and I'll close with gratitude. It is hard being an investigator. It's not popular. I feel when Shannon says you get to be a target on your back. I know I was the victim of it in a report. I'm grateful for a watchdog agency, and integrity is super important. If no other office gets it right, the Office of Inspector General should get it right. Looking forward to understanding this task force recommendations, how to implement safeguards so that all people can be afforded due process. Thank you so much, and I welcome any comments.
Questions? Okay, thank you very much.
Thank you.
I actually do have one question.
Sure.
In terms of just focusing on process
Yes.
right now, the timeline is you received an email in connection with an investigation asking you to submit to an interview.
Correct.
You responded to the email saying, I'm unavailable, but I'll be available next week.
Within 24 hours. Correct.
And you followed up with an additional email.
10 days after I didn't hear anything from them.
Okay. At any point, did anyone from the IG's office reach out to you?
They did not.
Okay, thank you.
Thank you so much.
Just to be clear, the email you received was from the OIG.
Correct. It was from the 2 people that were investigating.
No, you got it. I'm just, no, okay. All right, thank you.
Thank you, guys.
I'm just, all right. Next presenter, please.
Next up, we have OIG Board Member Cicely Welch.
Good afternoon, Madam Chair and task force members. I have taken a COVID test. This is just regular flu, but I'm still keeping the mask on. I'm Cicely Welch, and I was nominated to the governing board in the fall of 2022 by the Georgia Society of CPAs. I've been a licensed CPA in the state of Georgia since 2009, and in Illinois since 2002, and Atlanta resident since 2018, and operate multiple businesses within the city since 2022. Thank you for allowing me the opportunity to provide my input today. It's an honor to serve as a member of the board, and my comments reflect wanting to maintain the effectiveness, independence, and public trust of these organizations. Odie Donald, the mayor's chief of staff, spoke and presented at our September board meeting, and his comments solidified that the collective goal of all those convened is to strengthen the city's ethical environment. However, I believe there's a disconnect regarding the processes and operations of the respective offices. And, excuse me. And I'm highlighting here what I believe those to be. The Ethics Office and the Office of the Inspector General do operate outside of the typical or standard reporting structures within city operations. And this is a feature, not a bug, of its design. Further, the governing board has not intervened with the offices as it relates to initiating, carrying out, or implementing, or completing investigations. As I highlight a few areas of concern that the Chief of Staff mentioned, you'll see my comments consistently reflect my belief that as a board member, that we intentionally do not insert choice in what the respective offices are allowed to investigate. I believe the insertion of choice in their various functions and/or the breach of confidentiality. Thank you. Or, is this the? Oh, it's this one. Thank you. I believe the insertion of choice in the various functions and/or the breach of confidentiality hinders the effectiveness of the offices and would serve to erode the public trust in the office of the Inspector General and the Ethics Office. I aimed at which direction? Got it. So in the presentation that we received in our board meeting, there were some areas of concern that were presented that I wanted to address. One of them was lack of review or authorization for an investigation, lack of criteria or standard of review. As a board member, this is not an area of concern for me. As I've indicated, I do not think that it will be valuable to insert choice into what's investigated and what is not. If the office receives a complaint, they investigate it. Confidentiality, that was also listed as something that was a concern. During the September meeting, the confidentiality is a area of concern specifically related to, as a board member, I believe that the investigations and interviews should remain confidential as possible to maintain the smallness of people who know, to reduce the opportunity for coordination between parties, to reduce the opportunity for retaliation, and to reduce the opportunities for negative consequences when there are no findings. There was also a concern about violation of personal space. As a board member, and the information that we received, this was not something that I thought was an area of concern. In the current environment, people are working from home, people are working remotely, people are working at the office. Therefore, there are going to be times when you will get an investigation where you are working. So investigations will be in all of these places where someone is working. I also wanted to bring up the issue about specific access requirements and device seizures, etc. If we're using city resources, then we should allow access to those devices. That's what we're doing. Adding additional levels, additional levels of permission, additional processes to get access to devices, interviews, et cetera, expands the circle of knowledge. And if you look at the actual statistics that the Ethics Office and the Office of the OIG has presented, there's a significant portion of their investigations that result in no findings. Finally, those were my addressing the areas of concern that were presented to us during that board meeting. My areas of concern as a board member is reinforcing that inserting additional layers of oversight and processes hinders the ability of the respective offices to remain independent and for investigations to remain confidential. The OIG issued a letter in August of 2024 that was concerning a complaint. The office conducted its investigation based on the information from the complainant. The response, I'm not going to get into all the details of the actual investigation because to me that's not relevant. What's relevant is when you read the response to the issue, to the findings, they were not in line at all with what was written in the findings. There was a disconnect on what the complainant said versus what the office investigated and what the office found. There was also a statement about it should, the investigation should have just been summarily dismissed. Well, I don't think that that would be the case. If the office gets a complaint, they investigate it based on the processes and based on the procedure. I do not think as a board member it would be appropriate to insert any functionality of choice. I think, as a few people have mentioned here, the disconnect appears to be on what people believe the office's functions are and their mandates. An investigation is uncomfortable, it's intrusive, and it can also be disruptive. These are all accurate statements. However, that's the function of these offices. And as indicated from their statistics that they present on a monthly meeting to us as a board, a significant number of the complaints are closed and settled with no findings. However, the investigation, even when there are no findings, is still going to be uncomfortable, intrusive, and disruptive. It is for these reasons why confidentiality should be maintained, why fairness in fact and appearance is critical for public trust, and inserting processes and steps that give, in fact or appearance, choice in what the officers investigate is of significant concern for me. I do understand the need to have the offices follow specific procedures and processes, and that is what we as a board do. We want to see, are you following the processes that you have laid out versus evaluating what they should and shouldn't be doing. Is there consistency across board? I also understand why these different policies and processes, specific policies and processes, would not be published. As the CPA and someone who's gone through and done multiple audits, there's a reason why the IRS doesn't state, here's what we're going to look at in audit. The same would be the case if they laid out their specific processes that would potentially hinder the ability to have independent investigations. It is accurate that some complaints will be filed by rivals, some complaints will be filed based on misheard partial conversations, some complaints will yield recommendations for better adherence to city or department policies, and some complaints will yield findings of true wrongdoing. But because the offices do not have any way of knowing what the outcome of a complaint is until it is appropriately investigated, the appearance of independence and confidentiality in word and in deed is critical to the functioning of these offices. And my comments here highlight the board's, the offices, et cetera, understanding of its operations differs from the expectations of city officials and of departments. Excuse me. I support the recommendations that I believe you will hear from other board members, and that is in the letter from the Association of Inspectors General, to seek more substantial input from both offices and subject matter experts that do the work on a daily basis. Because all of the stakeholders may not agree on how the offices achieve their mandates, I strongly believe that permitting the Office of Inspector General and Ethics Office more opportunity to give you more information, which you did mention earlier, would be prudent and beneficial for all of us who are working to create a culture of ethical government. I thank you for your time.
Thank you. Questions?
Do you have a question, Madam Chair? You referenced I just want to make clear, just to make sure I understand what you just said about policies and procedures being kept private. Is that what you're saying? Is that what you're saying, that you believe that policies and procedures should be kept private? I'm not talking about specific investigations. I'm talking about policies and procedures.
I should differentiate between policy and procedure. What the policy is, what the OIG does, what the Office of Inspector General does, that makes sense. But the specific day-to-day, how we go about doing it, or I should say how they go about doing it, yes, I do believe that.
Have you ever reviewed, for example, SOPs that are published by the Atlanta Police Department that governs their work?
I have not.
Okay. Do you know that they are available publicly?
Yes.
Atlanta PD's SOP. Is there some reason why you think the IG should be treated differently?
I do not view the IG as comparable to the police department in terms of what their mandate is or what their operations are.
So I guess the Atlanta Police Department investigates crimes as serious as capital murder, assaults, everything under the sun. Their SOPs are public. Why would the IG's SOPs be different in that way? What distinguishes the work of the IG's SOPs being public from, let's say, the Atlanta Police Department that conducts sensitive investigations as well? So make sure you understand what's in an SOP.
I understand your question, and I am not prepared to answer right now, but I will.
Okay, thank you.
Any other questions? All right. Thank you.
Thank you.
Let's go back and hear from Ms. Good, and then we'll take a comment.
Next up, we'll call back Ms. Maisha Good, Department of Customer Service, ATL 311.
Good afternoon and thank you for giving me the opportunity to speak. I'm Commissioner Good. I serve as the Commissioner of Department of Customer Service, ATL 311 as stated. So back in August, I had an interview with the OIG's office. In the interview, it was stated, really wasn't much was stated, let's say that. So when I got the interview, I was informed that I can bring an attorney with me. They did not say if it was a personal or if it was city attorney. So after speaking with the city attorney's office, I was assigned a deputy city attorney to accompany me to the meeting. So when we got there, we were told that I could not have a city attorney there. And I think that would have been helpful beforehand, right? Just sort of just laying down the rules or expectations of the meeting. So when I got there, I could have known that, because I would have brought my own professional or my own legal attorney with me. And then secondly, I did not know if I was being accused or I was a witness to something, or who knows, right? And so that was not clear to me at all. I think when you have these meetings, that first just tell us what the expectations are, what we're getting ourselves into, if we could bring an attorney or not. Also, what is the agenda? What are you asking? And if that can't be shared, just let us know at the end of the meeting or interview next steps, right? So it's next steps, we're gonna have 30, 60 more days of investigation, or will there be a follow-up with me, maybe, because they did say there's an opportunity where they may come back. But I think it would be helpful for those that you're interviewing, just to understand what's next, right? And are you the person that the complaint was lodged against? I think that would be very helpful. So just putting some parameters in place, some expectations of some do's and don'ts would be very helpful. That's all I have.
Thank you. Any questions? All right, very good.
Thank
Thank you very
you.
much. Let's take a 5-minute break. Okay.
All right, we'll take a 5-minute break. Everyone should be back at 4:59 p.m. We'll just make it 6 o'clock.
calls the committee in session. Mr. Vasquez, I have the next one.
Close the door.
Next up, we will have Georgia Public Service Labor Organization, Mr. Bernard Barrera.
Good afternoon, Madam Chair and members of the task force. My name is Bernard Burrell. I'm the Executive Director of the Federation of Public Service Employees. We are the fastest growing public employees organization in the state of Georgia. We have approximately 500 members that work in the city of Atlanta. Our members and our city employees work hard to play by the rules. They are career civil servants. The city of Atlanta works because they work. We are concerned about the emerging political perception within the Office of the Inspector General. We are reminded that our perceptions are in fact our realities. We must remember the appearance of fairness and objectivity is as important as fairness and objectivity itself. We make no comments or findings on the current Inspector General or the office. We do not know. But what we do know is that willy-nilly investigations, rough riding roughshod, or operating without a clearly defined process is a formula for failure. We offer the following 6 points for the task force consideration. 1, we ask the task force to provide greater clarity on the role, responsibility, and the limitations of the OIG. We do not believe the OIG is the FBI, the GBI, or even the APD. Actual law enforcement and criminal investigative agencies have specific guardrails, and the OIG should as well. 2, we ask that the task force ensure that employees be advised as to whether they are subject of the investigation or a witness in the investigation. 3, we ask that the task force ensures that if employees are informed they are the subject of an investigation, that they be advised that they are entitled to have a representative of their choice present. 4, we ask that the task force put in place mechanisms to ensure that the OIG does not become a powerful, unelected bureaucrat with the ability to bully, intimidate, or improperly influence political campaigns or duly elected officials. This type of practice was made famous by J. Edgar Hoover, who became even more powerful than the President of the United States. We must ensure that the OIG office does not become a de facto political operation. 5, we ask that the task force recommend policies to ensure the OIG office does not morph into an arena of political shenanigans. We cannot have investigations that amount to assassination by investigation or assassination by insinuation. It is critical to know what type of allegations invoke the involvement of the OIG and the consequences if knowingly filing false allegations. Lastly, we ask that the scope of the OIG investigative authority be clearly defined and spelled out. What if something is being investigated by APD, HR, the law department, the city commission, the committee on the city council, the city of Department of Investigators? Who has the jurisdiction? As well as who has the authority? Which agency should the employee file their complaint with or respond to? There are more questions than answers. Clarity here will help us in understanding the process as well as maintaining credibility and decorum. Thank you for the opportunity to participate in the process and your expert service to our city. By working together, we can make Atlanta an even better place to work and call home. Thank you.
Thank you. Questions? Thank you very much.
All right, next up we have Executive Director Tracy Thornhill, acting.
Good afternoon. My name is Tracy Thornhill. I'm the Executive Director of ASME Local 1644. I come as one, I stand as 1.4 million, the largest sector employees union in the country. By city ordinance and the MOU with the mayor, I represent 3,500 city employees, grades 18 and below. It is an understatement to say that we are concerned about the process of the Inspector General, especially as it relates to city employees. My office has received reports that the Inspector General staff showing up unannounced at homes of city workers, compensating or threatening to compensate personal property and demanding access to employees' personal information. I've witnessed the actual Inspector General show up to a city council meeting uninvited, unannounced. It surely created gossip in the workplace to undermine the credibility of the city, of the Inspector General, and generally is viewed as political theater. Common sense dictates fairness demands, and clear process with checks and balances on the established. We would like for the task force to explore clear and published rules regarding the authority of the Inspector General, policy to make sure employees have the benefit of their union representation, limit the powers of the Inspector General to investigate major waste and fraud only, make sure the Inspector General does not undermine the roles and authority of city officials and agencies, require policies established by the Inspector General to be approved by City Council, including public input, define the process of the entity to file a complaint against the Inspector General. We don't necessarily disagree with some of the findings of the Inspector General, but how you get there matters. Credibility matters, process matters, integrity matters, professionalism matters. Current city ordinance and our MOU with the mayor requires classified employees 18 and below to be entitled to a union representative if in the city of Atlanta that may lead to discipline. Does the Inspector General have the veto power over our current city laws and MOUs? In the final analysis, we urge the task force to put in place clear and plain, fair rules and regulations to protect the interests of our city employees and the integrity of the process. Thank you for the opportunity and the concerns, and thank you for listening to me. And I want to give you all a copy of the MOU, the part that protects my employees 18 and below, where they have a 24-hour window to get me or somebody to represent them in any case of any investigation or anything. You have to give them a 24-hour notice. Thank you so much.
All right, thank you very much.
Question?
Yeah, are there any questions?
Y'all got enough? I got an extra.
Thank you.
So next we'll have Ms. Humetta Umbry, Edos.
All right, good evening, distinguished members of the task force. I am Hamita Embry, the Labor Liaison Officer for the City of Atlanta. Before joining the city's Department of Labor, I worked for organized labor in both the private and public sectors for more than a decade, from California to Georgia. Additionally, I served in an executive leadership role with the AFL-CIO in Georgia, working with a cross-section of over 60 different labor organizations. I have negotiated collective bargaining agreements that deal with the processes and protocols of employees' participation in investigations in investigative interviews. My experience also includes participation in unfair labor practices that brought about charges with the National Labor Relations Board, as well as litigation around labor disputes. So my transition from labor to this role is rooted in a commitment to ensure that our employees feel supported and valued. The bedrock of effective labor relations is to ensure that all parties are operating from the same base of understanding. Put simply, the rules of engagement must be clear. The process must be understood, and the employees must be entitled to representation. Without transparency, clarity, and entitlement to representation, I am concerned the process will lack credibility. It is important that our city employees understand the full scope and various avenues they have to raise legitimate concerns or to file complaints. And equally important is the ability to have representation throughout the process, whether filing a complaint or responding to one. One of the key aspects of this effort should be educating employees on the process and their rights. The Atlanta Department of Labor and Employment Services, coined as ADLES, is currently working on an educational document to support the efforts of the Office of the Inspector General, the Ethics Office, and this will ensure that the expectations and the administration of the investigative process is clear. The education will include the role and responsibilities of the OIG, the Ethics Office, as well as guidelines for responding, participating, and supporting ethical government. To foster this environment, the city through ADLES is aligning its operations with the 7 best practices of enforcement. 1, transparency. All processes should be clear and easy to understand, leaving no ambiguity for any employees. Fairness is number 2. Every case must be handled with impartiality, ensuring that all employees are treated equitably. 3, accessibility. Employees need easy access to resources, guidance, and representation throughout the enforcement or investigatory process. Number 4, consistency. Decisions should be made consistent and based on established standards so employees know what to expect. Number 5, timelines. Investigations and resolutions should occur with a reasonable time frame to avoid prolonged uncertainty. Number 6, collaboration. Maintaining open lines of communication between the investigating authority, labor representation, and employees. This will help to build trust. Accountability. Ensuring that both the investigating authority and all city departments are accountable for upholding ethical practices. My goal is to ensure every employee feels supported and fully informed about their rights and the processes available to them. This approach is essential in fostering a workplace culture of transparency, trust, and respect. I look forward to collaborating with the task force to ensure that these best practices are fully integrated into our organizational framework and that every employee and stakeholder understands their rights and roles and responsibilities. Thank you.
Thank you. Questions? Okay, thank you very much.
Next up, we have Mr. Bernie Tokars.
Stephen Katz, and I represent Mr. Tokars, who's here with me today. Mr. Tokars is the subject of a OIG investigation, a 42-page document that was tendered in August. And there's a lot I could say about the facts. I won't go into it because it's fall asleep. But also beyond the process because when you're dealing with facts but process. But there were some recurrent themes that came up. There were very serious issues, one of which was a First Amendment issue involving a very prominent city friend of my client's for all his life. Another issue that came up during this, in this report, was preemption, whether or not state law actually preempted an investigative area. It's a very serious matter. And there was issues regarding the scope of the investigation and how far the OIG went beyond the actual complaint. And what happened here is we realized at the end of the day there was just no oversight, no real policies or procedures to deal with it. Because what we got was a 42-page letter, in our view, defamatory. A private citizen, we probably wouldn't listen. But it was really, really way out of bounds. And so, where do you go? It reminds me of the story of a cabinet member in the 1990s who was indicted and he was acquitted, and he went to the U.S. attorney and he said, "Look, where do I go to clear my name? Where do I go? What agency do I go to?" Well, at least that cabinet member had a public trial. At least that cabinet member had a forum to go into somewhere to seek redress. Here, all we had was this letter, and all we could do was respond to it. But the allegations were out there. They were still out there, and these serious issues, we had no one to go and address. We had no one to address the First Amendment issue. We had no one to address the scope of it. We had no one to whom we could address the preemption issue. And that's true today. There are also serious allegations regarding policies and procedures about retaliation. Last week, 2 months after the report was issued by OIG, there was a referral to a state agency. A referral to a state agency. And the referral, which we have, included all kinds of personal information from my client. And the OIG wrote to this state agency and said, "We discovered all this information during the OIG investigation." And we were kind of shocked because nowhere in the 42-page letter did any of this come out. So what we're left with is thinking, hey, wait a minute. This complaint to the state agency was issued only after we responded to the OIG by writing the recipients of the letter. And there's no policy, there's no procedure, there's no oversight regarding any retaliatory measure. So what I would say at the end of the day is that there needs to be some mechanism for oversight. There needs to be some process and procedure by which serious issues like the preemption issue, like the First Amendment issue, can be dealt with, because OIG is something akin to a federal prosecutor, with a wide scope of authority with really nothing that we can see that would limit that authority or provide any oversight for this kind of broad investigative process that takes place. So, I'd be happy to answer any questions that you might have. We're here to argue for oversight and more effective procedures governing the OIG office.
Thank you. Any questions?
I just want to talk about the process. I don't want to talk about the merits of the investigation. So, as I understand it, the OIG has a mechanism by which you can appeal findings or conclusions, I guess, to the governing board. Did you avail yourself of that process?
Well, we really didn't regard that process. It wasn't outlined, there's no appeal procedures outlined in the letter so far as we could see, which common when we're dealing with federal agencies.
So when you received the notice of the findings, I guess you're saying you did not receive information about the right to appeal?
Not that I'm aware of.
Curious, at any point in the process, was there any notice of what the allegations or the claims, were?
There was, during the process, when we got the letter, we looked at what was alleged in the complaint, and it's the kind of thing that, if given a federal court and before a U.S. magistrate, throwing it out on a frivolity determination. We looked at it.
But prior to receiving the 42-page letter, there was no.
So I have a question regarding the scope, and not to get into the details of the investigation, but my understanding is the Office of Inspector General oversees the officers within the city of Atlanta. So how does this fall over into an investigation of something outside the city of Atlanta? You were speaking in general terms, was the investigation, I guess, started within an office and then proceeded from there? Or was this just? Yeah, it was, I mean.
No, I think it was just some random person who complained that I didn't understand.
Was it a vendor, or what was the relationship in the city of Atlanta?
I'm a city
Yeah.
Yeah. So there was an accusation that I also worked for the city,
Okay,
which I've never worked.
but you were a city.
Correct. And so once you determine that I don't never work for the city.
Okay. All right, thank you very much.
Next up, we have OIG Board Member, Mr. Todd Gray. And I'd like to state for the record, I did receive written statement from Mr. Gray. Could be included into the record.
All right, good evening, Madam Chair and to the task force. My name is Todd A. Gray. I serve as the current Vice Chair of the Governing Board of the Office of Inspector General and Ethics, and have served on the board since 2015. I'm appointed by the Atlanta Business League and have served in this capacity with the utmost commitment, integrity, and leadership in which this position requires, with the singular mission of assuring there is no safe place for unethical practices, crime, or corruption within the city of Atlanta's government. I have stood at the forefront in the fight for the full independence of the Governing Board, Ethics Office, and the Office of Inspector General. In this fight for independence, it is mission critical that the City of Atlanta's best practice model for independence is upheld and protected at all costs. I stand with the Governing Board, Ethics Office, and the Office of Inspector General. We have now come to a critical juncture where we have the opportunity to strengthen the effectiveness of all three entities. I want to thank the well-qualified task force and its members for not only the mission at hand, but for your countless individual contributions to the City of Atlanta and the state of Georgia. I would like to make the following recommendations to this task force as you seek to carry out this important work. Number one, receive in full account the submitted statements from the OIG, the Ethics Office leader, and the Ethics Office leader. In doing so, it is extremely important to understand the combined mission and role of the board, the distinguishing functions of the independent offices, and where their jurisdictions may overlap. Number two, the governing board needs more oversight authority. While both offices operate in full independence, and it should remain as such, there is a dire need for required collaboration by way of the charter to ensure that industry best practice, due process, and collaboration is the foundation of this work, no matter who holds the top positions in either office. Number three, it is of my opinion that the governing board, who is charged with the hiring of the Inspector General and the Ethics Officer, is not only empowered with this administrative step, but also empowered by amendments to the charter to provide more effective oversight and collaboration with the common goal of supporting the mission-critical work these offices conduct on a daily basis. There should never come a time where the board is blindsided, uninformed, and limited in the feedback and support we can provide towards our collective mission. Due to the potential leadership style of the individual who holds either position at this time or any future period. The governing board should be proactively engaged, in addition to the rightfully constituted tools in which each officer holds, at points of challenge and times of necessary escalation, whatever the hindrance may be. The defining of a proper performance review process by way of the charter and bylaws to ensure non-biased performance evaluation of the office's top leaders by the board and its members. In closing, the City of Atlanta got it right when it comes to the best practice independence model of the Office of Inspector General, Ethics Office, and nominating requirements of the governing board and its members. The Mayor's Office and Executive Branch have on numerous occasions made themselves available and serve as champions of this mission-critical work along with the board. To the accounts of the current leaders and staff of both the Ethics Office and the Office of Inspector General, which was established in 2020, there have been challenges and successes over the decades in executing the daily task at hand. I stand in support of this task force, both the Ethics Office and the Inspector General's Office and the nominating organizations. I also stand in support of the best practice organizations across this nation who serve as advocates for this powerful work. I trust in full that the collaboration between this task force and aforementioned entities will result in further protection of the independence and effectiveness of both offices and its governing board. We all work for the public, and this work to weed out corruption and unethical practice must be done in accordance to the charter and our bylaws, all while upholding the rights of the individuals involved, no matter the circumstance or the actions at hand. Sorry, Greg. Any questions?
Thank you. Any questions? Okay, thank you very much. Well,
Thank you all. Thank you.
So next up, we have OIG Board Member Terry Simmons.
Good evening. My name is Terry Simmons, and I was nominated to the governing board in the fall of 2022 by the Gate City Bar Association, then appointed by the mayor and council. I've been licensed in Georgia for almost 15 years and an Atlanta resident since 2012. It's been an honor to serve in this capacity, and I thank you for allowing me the opportunity to provide my input. It's concerning that there may be legislative proposals that threaten the independence of both the Ethics Office and the Office of Inspector General, and I'm concerned whether existing legislation gives the governing board tangible oversight powers. I believe city policies must acknowledge each office and their authority, and education led by the Office of Inspector General and Ethics Office on their distinct functions is imperative for the city. With a strong foundation of knowledge and collaboration, many of the challenges and concerns expressed could be improved or alleviated. The collective goal of all convened is to strengthen the city's ethical environment, even though some may disagree on measures to achieve that goal. Without improved city policies, a culture will grow where city leaders and employees fear the Office of Inspector General and Ethics Office. Fear discourages transparency and deters whistleblowing. To this point, I refer you all to the 2019 report of the Task Force for the Promotion of Public Trust by the Honorable Leah Ward Sears Chair. I quote, "The right tone for ethical leadership must be set at the top by all of the city's leaders. It doesn't matter how much effort is made to ensure that a rigorous system of accountability exists. In order to strengthen public trust in government, the city's leaders, meaning collectively, all of its managers, officers, supervisors, appointed and elected officials must set high expectations for ethical behavior and follow through on that commitment at every turn. The Office of Inspector General and the Ethics Office are separate by their distinct jurisdiction and function. Thus, each office's education and training for the city, including all elected officials and employees, must be conducted separately. It should be mandatory and regular and encouraged by city leadership. The governing board has unsuccessfully proposed legislation to improve our oversight. While both offices voluntarily comply with our requests for final decisions upon the completion of investigation, that compliance is not required by legislation. Given the governing board's lack of continuity, members serve for exaggerated 3-year terms. Inclusion in the legislation would ensure consistent oversight over the changing nature of the board. Prompt receipts of reports allows the board to analyze specific metrics and trends and assess the efficiency and conduct of each office. Currently, we request how many cases are opened and closed during each reporting period, the time duration of investigations, metrics from the prior reporting period and the year prior and year-to-date metrics. Again, legislation does not require this at this time. That's something that we've asked of both offices, and they voluntarily comply with that. Legislation requiring the production of final decisions upon completion of investigations strengthens accountability through oversight and provides continuity for future governing boards. Another proposal concerns the scope of our ability to render decisions on appeals and motions to quash subpoenas. Current legislation only allows the governing board the ability to affirm or overturn decisions and to quash or uphold subpoenas in their entirety. Legislation should allow the power for the board to modify fines imposed and modify the terms of compliance with subpoenas, all in the interest of fairness and justice. This also strengthens accountability through oversight. Now, it should be acknowledged that there are ways the current legislation promotes accountability and independence. The makeup of the governing board is a truly thoughtful, unique, and a wholly independent process. Appointees known for their personal integrity are nominated from diverse organizations, subject to appointment by the mayor and council. The governing board then appoints, subject to confirmation and approval by the council and mayor, both the inspector general and the ethics office. Both the inspector general and the ethics officer must be experienced and in good standing with the State Bar of Georgia. Both have limited 5-year terms and are subject to removal at any time for cause by the governing board. Seemingly, there's also legislation that allows the Department of Law to institute their own investigations into either office or even the governing board. So there do exist explicit checks in the current legislation and authority enabling the office's independent functions. Peer reviews and independent counsel for both offices should be included in legislation. With peer reviews, both offices would be required to explain and justify their practices, investigation, and use of their powers, and would be evaluated on their effectiveness and efficiency by experts in their fields. Independent counsel, reporting directly to each office, can provide legal advice, make sure both offices are following the law, and protect the rights of all involved. There is a concern that proposals to legislation or city policy would threaten the independence of either office or may conflict with best practices and quality standards. There are serious concerns voiced by the Office of Inspector General regarding obstruction of investigations. While the legislation contains explicit terms requiring all city officials and employees to cooperate with both offices' investigation and to allow immediate access to public records and property, city policy needs improvement to define what constitutes cooperation and immediate access. Collaborative education and training from each office encouraged by city leadership is imperative here. Both offices require special, broad access for the purpose of uncovering ethical violations, fraud, waste, abuse, and corruption. Neither the governing board, the legislation should prevent either office from initiating, carrying out, or completing investigations. The 2019 Task Force report addresses areas of concerns that were expressed in the mayor's Chief of Staff's presentation explicitly. It recommends the IG's need for broad jurisdiction and access beyond what is normally accessible. The requirement for city leadership and employees to cooperate with the IG and report wrongdoing to the IG, the need for confidentiality of investigations, the need for the IG to be able to initiate investigations into a wide range of matters, and that the legislation should have the opposite of a notification provision and instead confidentiality provisions. Proposed legislation or policy requiring the governing board or any other entity to approve the initiation of an investigation or to place similar conditions on either office's abilities to initiate investigations create a host of confidentiality problems due to the public nature of reporting to the board. Confidentiality is not only important to protect the integrity of the investigation, but to also protect the subjects of the investigation from the disclosure of potentially unfounded allegations. A detailed discussion of confidentiality considerations and why the offices should not have to seek permission from a board to act is set forth in the 2019 report, and I believe those same considerations should apply to any limitation on the initiation of investigations. Public reporting of
We have 1 minute left.
Public reporting of final decisions is an important feature that should not be limited because it builds public trust. Public reporting deters wrongdoing and provides the public and those responsible for city policy to be informed and educated on what's proper and improper activity and can guide city leadership on policies to prevent wrongdoing. Non-responsiveness from city departments after receiving recommendations from investigations is very concerning. It's important for city policy to provide a mechanism requiring department heads to respond in writing to all policy recommendations from the offices. Finally, I respectfully request the task force permit both the Office of Inspector General and Ethics Office adequate time to prepare for and adequate time to make presentations separate from the time allotted today in order to sufficiently address all concerns and perspectives. I also ask the task force to allow for presentation by subject matter experts for offices of Inspector Generals and ethics officers prior to rendering any decisions, including decisions impacting the authority of the board. Thank you for your patience and consideration. Did I do it?
Yeah, you
Okay.
What happens is, well, if there are PowerPoints on, there's no clock.
I got you.
So I just can't tell.
And I practiced it, so I'm glad I made it.
Great.
Okay.
Thank you. Thank you. Any questions?
Question, do we have a copy of your
You should, but I also made some grammatical changes and I would love to give you my updated copy. And I don't think you can see the footnotes on the copies if you just pull them up on your computer or so I do have copies. Yes, and then I've been taking notes and I would like to address, if possible, some issues about the legislation's language on subpoenas. I heard that come up, if I could.
You don't have to do that anymore.
Okay.
Your presentation time. Are there any other questions?
I do have a question. If a person wants to appeal to the governing board, is there a mechanism for them to have counsel, or do they have to pay for their own counsel? How does that work?
So the legislation provides that decisions from the Office of Inspector General or the Ethics Office can be appealed to the governing board. We've had appeals from the Ethics Office because they actually issue final decisions.
Okay.
We've never had appeals from IG because even though the legislation says that they can appeal the decision, IG doesn't issue decisions, they just issue whether or not the allegations have been substantiated or unsubstantiated, along with referrals potentially, along with policy recommendations. So I guess per the legislation, my read of the legislation, they could appeal it and they could come before the board and discuss it, but we don't have the ability to, I guess we could, the legislation does not make a distinction, in my opinion, between a final decision of the ethics office being appealed versus recommendations and referrals from the IG's office.
So then what would be your standard of review?
Well, we
On
have,
both subpoenas and appealing?
we have a standard of review, and it's by the preponderance of evidence, and that's set forth in the legislation. I'm just saying that practically speaking, we've never had, since I've been on the board, anybody appeal a IG report and recommendations, because that's different than an actual final decision from ethics office that could have fines.
But is it a de novo review of the?
That's what I was speaking to with the proposed legislation. We are only permitted to affirm or overturn decisions or quash or uphold subpoenas in their entirety. So for instance, and I put it in my footnote, let's say we don't agree with the fines assessed by the ethics office with respect to some wrongdoing. Let's say we would like to order or institute a payment plan for those particular fines. We don't have the ability to do that at this point. Let's say that there's a subpoena that we would like to uphold, but due to the nature of the person that's having to respond to the subpoena, they might be asking for 90 days, right? Because they might need to go dig through some boxes that are in storage, whereas the office might be saying we need it in 30 days. We don't have the ability to alter that in any way at this point.
So if you issue a subpoena concerning a subject's property or their investigation, who has the standing to appeal? Is it the worker or is it the person responding? And then does the worker have notice of a subpoena that has been issued?
Well, we wouldn't issue a subpoena. Either office would issue the subpoena. However, the legislation allows for us to hear only the issue of if someone were to file a motion to quash the subpoena. That's the only way it comes before the board. The legislation provides that provided someone does not follow a subpoena, they can take any action, if let's say someone does not answer a subpoena, either office could appeal to whatever appropriate court in order to have the subpoena enforced. Now, what I think is very convoluted about the legislation, usually when you have the ability to appeal to a court, it'll tell you what court you can appeal to, it'll tell you how, by a writ of certiorari. It does not say that in the existing legislation. All it says is essentially they can take, the failure to, if somebody does not comply with a subpoena of public records and property, the Inspector General or the ethics officer shall report such failure to any court of record or judge thereof in accordance with applicable law. Exactly, and I think that's another proposal to legislation that actually came up from a question to be more specific about the terms in which, how you would appeal to Superior Court. I would assume that would be to issue, for a court to issue a subpoena.
All right, thank you very much.
Thank you.
Very good. Next presenter, please.
All right, that would technically be the last, unless you want to consider the presentations from HR. I'm not sure. It's been the return.
Oh, I don't know, there's one more that I'm saying.
This would conclude if you're not considering the presentation from HR from Ms. Kimberly, pending from earlier.
Yeah, but let's go with it. Is she here now?
Calvin Blackburn, Administrator, she's not going to be on that.
She's
Just
not.
gets that boy.
So that is.
That will conclude the presentation.
Okay. Thank you very much. You all know we are mandated to hold at least 3 public I'm sorry. Can you hear me now?
Yes.
And thank you for telling me to turn on. We are mandated, ladies and gentlemen, to hold at least 3 meetings publicly. So I want to confirm that the date and the time for our next public meeting, which we all agreed, I believe, is October 16th, beginning at 3:30. Okay? So we'll be having that meeting at that time. Remember, our task force adopted rules allowing for public comment, even though we weren't technically required to do so. We approved 2 minutes per speaker for up to a total of 30 minutes. Give me 1 second and let me just confirm with my fellow staff. Go ahead and go to the public comment. Do you have any parties who signed up for public comment prior to the meeting?
Yes.
If so, would you identify your first speaker?
Yes. So at this time, we have 10 speakers that have signed up for public comment. First up is Ms. Shanae Hall.
You have 2 minutes and, try to be kind, but please try to watch your time. My tone? Time.
Oh, my time.
Yeah,
Oh, you're asking a lot.
and I'll watch the clock, I can see where you're going.
Yeah, I wrote it.
So I'll try to be,
I will try.
okay, thank you.
Thank you, guys, for having us again, allow us to speak. I want to just address some of the concerns that I heard that the mayor had concerns about and listening to them. So the mayor had concerns about the method in which the IG was conducting investigations and how they were initiated. Here's what I want to point out. November 2022, Shearbaum reached out to the HR director, Patrick Pendleton, to open an investigation about my mom's work performance. She was the deputy director for public affairs at the time. Shortly after that email, she was sent home and literally locked out the building without giving her notice of why. March 2023, Chada Spike sent an email to Darren Shearbaum, Peter Amon, that read in summary, Frost's daughter produced an Instagram video describing a homicide case involving Shaka Zulu that made APD look bad. In April 2023, my mom sent a letter to the mayor addressing her concerns, and in that response, they said, we're looping Tarlisha in, who's now the fire HR commissioner. May 2023, the HR director, Pendleton, stated in his final investigation report, and I quote, there is concern regarding Frost's current status is due to a social media post initiated by her daughter, who was not an employee of the city of Atlanta. The mayor didn't have any problems with that investigation. He didn't mention no task force coming to help. Now let's discuss the city-owned property being seized without formal notice. July 10th, 2023, HR director and a sergeant showed up at my mom's house unannounced, seized all of her APD equipment, her phone, her badges, and she was still an active employee. They told her, you no longer work for APD. Mayor didn't have no concerns, no standard of review. So maybe it's just the IG, when she does it, there's a problem. But when APD does it, that's okay. And then what's funny though, is on her personnel report dated September 10th, it states Rhonda Frost resigned, signed by Darren Shearbaum. So if all of these things don't stand out to you guys as this policy and these employee rights and all these things I hear you guys talking about that you're putting in place, how does it really apply? Because when my mom, as a city employee that worked for the mayor, said I need help, nobody showed up. Thank you for your time.
Thank you. Thank you.
Next up, we have Mr. Jim Martin.
Yes, Jim Martinson, 64 Verner Street, Chairman of Planning AD. I heard everything that you all heard, and I would like to point out a few of my takeaways from all this. I heard concern expressed that the Inspector General may have a political agenda. I think that the concern that is motivating all of this is exactly the opposite. People are concerned that the Inspector General may not have a political agenda. And it is really through the lens of political agendas that everyone in this building seems to interact. And not having that lever against the Inspector General is a problem for many people. I would also like to bring up the question of whether or not personal property has been seized or employees have been accosted at their homes outside working hours. I heard at least twice rumors to this effect were stated, and yet these are knowable facts. And if we are going to listen to these things, I think we should hear what the facts actually are. Thank you.
Thank you.
Next up, we have Paul Zuka.
Mr. Zucker?
Next up, we have Tanisha Brown.
Tanisha Brown?
Yes. Next up, we have, make this out, Perkins. Next, kind of hard to make out, but Perkins.
Perkins?
All right, next up we have Williams, last name. Last name is Dye. Y-E. Kiki Reed.
Such a long meeting. I just want, y'all must be serious business heard, okay? I just believe in justice and fairness for all citizens of Atlanta, Georgia, as well as the employees. My question is, should an inspector be allowed to come to a person's home after business hours on the weekends, days off? Should there be a code of conduct for these inspectors? You know, I've heard that there may be some code of conduct, but I just need to understand it. Innocent until proven guilty. That's always fair to me. I want to know what's happening with that right now with some of these convictions. And once the officer has been allowed to present a report or publish a report on a employee, if the person is found not guilty, innocent or whatever, do they publish it as loud as they publish the wrongdoing? These employees, to me, after these things being published, they're embarrassed, as I would be. And they're like, why? Because people like to hear bad news. That's why the gospel columns and Instagram so popular. The department needs to replace, in my opinion, needs to replace some of these people sooner than later. Why? Because they should have integrity and some type of character before making some of these statements about these employees based on rumors or false information. We need to hold these people accountable. People's records are being handled improperly, in my opinion, because it's one of my neighbors, 20 to 30-year employee. Please, council, listen to this as soon as possible, and I appreciate you and your time. Okay.
Thank you very much.
Last person listed is Mr. Dewan Robinson. Correction, we have one more mistake.
Good evening, Madam Chair. I know you're a very conservative woman, Ms. Beers. I've studied your career. And Mr. Rick Dean, you were the first black U.S. attorney of the Northern District under Bill Clinton, so I know what you guys stand for. And I'm glad that you're on the board. I want to speak to some things that go on in Atlanta that you guys may not be aware of. We have about 5 top-heavy people at the airport, including the general manager and the deputy general manager. I went to the ethics and said, hey, here are these things that's going on. I was told, Mr. Robinson, you want me to investigate people at the top? I can't do it. I need my job. I went to the OIG office, investigated, 5 top people are fired. including our HR commissioner, deputy general manager, our general manager, and everybody up under them. I'm fighting. Moving right along. We have people that work for the city of Atlanta, working out the country, been at home since COVID. So if you're at home and the excuse is you're at home, where else am I going to come serve you at? At home, right? So we got to be honest about these things. There are some people in the city of Atlanta, directors and commissioners, that are doing some egregious things. You got to have somebody not scared to investigate these people, because guess what? Many are afraid. Many are cliquish in Atlanta and won't do it. I worked for the city of Atlanta for years in public works procurement. I was asked to sign a $10 million road pavement. I didn't even know what RFP meant at the time. I was asked to sign it. I didn't want to sign it. Guess what? I was forced to resign. I was cool with it. I'm just telling you, we got to have some people that got some teeth. Now, the OIG was created because they wanted to then lock American Scene Reed up by any means necessary. I don't care if you go to the house at 2 a.m. in the morning. You can subpoena whatever. Lock him up. Found no wrongdoing. Other people can investigate it. Oh, pump the brakes. We got to find, you know what I'm saying, common ground. You're doing too much. We can't have this. So we got to understand where we came from. It was okay when you wanted Kasim Reed locked up. It didn't matter what the roles were, what type of subpoena. Now, it matters. I do think that two things can be true, right? OIG should be operate independent. And if now we want to say what are the rules and how far we can go, yes, that's what we're here for. You know what I'm saying? But understand those rules didn't matter when you wanted to lock up then Mayor Reed.
Thank you.
Yes, we have Ms. Amy Stout.
My name is Amy Stout. As Mr. Gray noted, you all work for the public. I'm the public. I'm a 20-plus year resident of the city, and I pay significant property and sales taxes by having the honor of living here. I have used half a day of vacation to be here today to watch this. I also serve as the chair of my neighborhood planning unit, an unpaid volunteer position that I spend a lot of time on, and all that is to say that effective functioning of city departments is important to me, as is rooting out corruption in both hired employees, appointed commissioners, and elected officials. And it's me and most all other taxpayers, I would assume. I'm disappointed to see this proceedings today turned into a parade of people saying you're going after our unprotected low-level employees. I don't think that's what this is about. As another speaker noted, the tone comes from the top. And I'm more worried about people at the top. As another speaker said, the city works well, and it does for the most part. Most of these people are doing their job effectively and conscientiously, but there's a few bad apples that are making it bad for everybody, and they should want those people removed. I know I do, I think they do. The major thing I want to point out, the thing that sums it up to me, the tone is coming from the top, and the top is the mayor, and all the majority of the suggestions that he suggested for changing the processes, if you look at this chart, they are not best practices. So that just really struck me. So I hope you will keep that in mind. 2 minutes is longer than I thought. Thank you for your time.
Thank you very much. All right, ladies and gentlemen, I want to thank you all for coming, and I want to thank each of the members of the task force for their time and commitment to see this process through. It has been a very long day. So if there is no objection, I'm going to entertain a motion to adjourn. All in favor, say
Just for the record, I want to say a couple things. I am a long-time resident of Atlanta, former prosecutor, elected person, and so there are several people who testified today who I know, and so I just want to say who those people are. Ms. Singova, I knew from the Fulton County District Attorney's Office when she was a public defender. Todd Gray used to be my neighbor. FPSC is a supporter of my campaign, and I'm a contract attorney for them I'm a member of the Gate City Bar Association. AFSCME has supported my campaign. Dewan Robinson has supported me. Mr. Tokars has also supported my campaign, and so I just wanted to make sure that that was clear for the record. None of those relationships will impact my ability to abide by the oath that I took in my capacity to make recommendations about process and procedure. Thank you, Madam Chair.
Part of this meeting. Thank you. Thank you very much.